Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. Let's get our week started in Michigan with Judge Dad.
Not responsible to that.
That's the court, they would set me up a payment plan if that's feasible.
235. How much do you have today?
I put in a card, whatever, I can pay $50 or something.
Okay, you pay 50 now. When can you pay the rest?
Then within 1 month.
Are you working? You driving a truck? How much you make?
I mean, $24 an hour.
You work 40 hours?
Most of the time. Yes.
That's $960 a week. I'm gonna have you pay $50 per week. Pay 50 now, 50 per week. I'll start that beginning a week from today, September 22. Can you do that?
So
If you can't, if you don't have the money, you call the court, we'll go on Zoom. I'll give you an extension, okay?
yeah, if I want to, in 2 weeks, just be done with it, I can just call and pay over the phone.
Nobody's gonna refuse your money.
Okay.
Have a good day. Good luck. Thank you. Jeffrey Doug Day. 25T645-854. Your name?
Jeff Day.
Okay, so you're gonna plead to 5 over, right?
Yes.
Responsible or not responsible to that? All right, I'll accept the plea. 175. I don't see if the bond's in your name again, any, if it is, or, all right, you go down the hall and sign your bond over and you're all set. Slow down though. Lisa Clark, Lynn Clark, 25B149238. Your name, ma'am?
Lisa Clark.
All right, you're going to plead to impeding traffic, correct? Responsible or not responsible for that? I'm gonna accept the plea, dismiss the speed, 150, you're all set, okay? Have a good day. Hannon, Joshua Rodney Hannon, 25B149186. Could I have seated at the table here? DeJohn and staff, STAFFE. Your name? You're going to plead this charge, the expired plate, true? To that charge, responsible or not responsible?
Responsible.
Do you have a valid plate now?
Yes.
You have proof of that?
Not.
You have your wallet? Do you keep it in your wallet?
It's in my wife's. I've been her car.
When did you renew your plate?
I had an appointment for it, but it was a couple days after.
When did the plate expire? He didn't write that on here.
Expired July 21st.
And you're telling me you have a valid plate now?
Yes.
All right. I'll make it $80, okay?
Okay.
Go down the hall and take care of that. You're all set. Thank you. Stanley DeJohn. Stanley R. DeJohn Jr., 25W839513. Good morning, sir. Your name?
Stanley, you got it, Junior, got it.
All right, you're going to plead to impeding traffic, true?
Yes, Your Honor.
To that charge, responsible or not responsible?
Responsible, Your Honor.
Okay. $72 and $65, $150 is your total. Cash your end of the whole, you're right.
You got it, happy 50 today, then 100 on Friday.
Sure.
Thank you, Your Honor.
You pay 50 now and I'll just make the balance due by the 22nd, 1 week from today.
Thank you, Your Honor.
Have a good day.
You-
Crystal Lee Staffy or staff? 25T646259, your name? All right, you're going to plead to impeding traffic, true? Responsible or not responsible to that? Okay, I'm gonna accept your plea. 160 is your total. Cash your end of the hall to your right. Have a good day. Thank you. Sarah Elizabeth Vincenza, 25T646090. Could I have Aaron Harper and Madeline Curry seated at that table there? Your name, ma'am?
Mary Vincenza.
All right, you're gonna plead to impeding,
Yes,
responsible or not responsible?
responsible.
195, I see that these vehicles were unoccupied, so nobody was hurt. You're all set, cashier, be careful. You're veering in the parked cars.
Yes. I was told I could, have a month to pay it.
Who told you that?
The officer in there.
You just tell me when you can pay this. How much do you make?
I work, I'm a delivery driver.
Can you pay $40 per week?
Yes, again,
You pay $40 each week.
I can pay 40 today.
Okay, you pay 40 today, $40 a week, beginning September 22nd. That's a week from today. If
You
you,
want me to pay today and then,
and then 40 per week.
Okay.
And if you ever don't have the money, something came up, call the court, we'll go on Zoom. I'll be glad to give you an extension, okay?
may I pay more if I?
You can do that. There's no prepayment penalties if that's what you're asking me, okay? Have a good day. Aaron James Harper, 25F244556. Mr. Harper, how are you? You're gonna plead to expired plate
Yes.
to that charge, responsible or not responsible? All right. See something here. You had an expired plate for 2 years.
Yeah.
Why?
So, my car was in the shop like for like a real long time, and then I just like got it back out that week.
Your car was in a shop for 2 years?
Yeah, it was that's the problem. But yeah,
2 years? How much they charge you?
it was transmission on the.
You can't go without a valid plate for 2 years, 135. Cashier end of the hall to your right, okay? Good luck. Curry, Madeline Jean Curry, 25W839-540. Good morning, Ms. Curry.
Good morning.
Nice to see a smiling face. Your name?
Natalie Curry,
You're going to plead to impeding traffic, true?
yes.
Responsible or not responsible for that? All right, I'm going to accept your plea. You got a clean record, 150. Cashier end of the hall to your right. Have a great day.
Yeah, great day.
Farrell, Jackson Farrell. 24B82280. Jackson Farrell here.
Judge, he's on Zoom. I'm just not a co-host, so I can't let him in.
You know how to do that, Vince?
Vince can make me a co-host.
Oh, you can make her a co-host.
He's a bit.
Okay, perfect. Mr. Farrell, your name? You have to start your video and unmute, sir.
Is that it?
You need to start your video and state your name.
Jackson Farrell.
You need to start your video, though.
Is it going?
No?
Camera's not working.
Apparently the video camera's not working, sir.
All right,
I don't-
I'm gonna need you to come in here. I'm gonna reschedule this.
Sir, I cannot travel. I have no way to get there. That's why I
Well, I
tried to.
can't do it looking at the black screen. You're gonna have to figure it out, sir.
Well, I just identified myself, sir.
I'm not, listen. I'm not gonna argue with you, okay?
I'm not here
Okay,
for an
no,
argument.
please, I'm not gonna argue with you. I need to see people at least. This isn't, we could do this on a beach with a phone call if we wanted to. I'm not gonna do this. You're going to have to either figure out a way to start a video or come in here. I don't know what else to tell you.
Well, really, alls I need, I thought that I had till the end of October to finish the cleanup.
Listen, I told you to property to be cleaned up and in compliance with ordinances by August 31. That's what I said, but I'm not gonna go into this.
Okay. All right.
You're gonna have to call somebody to get somebody over there. And you gotta get it fixed or taken care of before you come back. So I don't
Okay.
know where you thought you had until October. Is that what you said?
That's what I thought.
Well,
I
I
thought we had
said,
until-
I said August 31. We gave you a copy of the order. It's clearly spelled out. It has to be taken care of by August 31. I'm rescheduling this in 2 weeks. You need to either have somebody help you get on video or come over here. So give me a new date, Amy.
September 29th at 9:30.
Okay, September 29th, 9:30.
I'd strongly suggest you have that taken care of if you haven't already. And I'm telling you, you're gonna need to be here. What do you mean? Why can't you come here?
I'm blind, sir. I cannot drive. And catastrophically disabled per the Veterans Hospital.
Have you been in front of me on this before?
Pardon?
Have you been in front of me in person on this before?
Before this, some number of years ago, you came over to my home taking pictures after I had been in the court with you.
I don't know if I took pictures, did I? I mean, for the
Yes, you
same
did.
thing?
Yes, you
Well,
did.
well, I wouldn't have done anything I couldn't do. I don't know. Was that
Well,
on the same? Hey,
I had advised you that the property was posted under United States Code Title 18, Section
all
241.
right, okay. I don't want to hear your nonsense. I didn't come over there and take
Nonsense,
pictures.
sir?
Listen,
Federal law is nonsense?
September
Okay.
29th, you're gonna be
September
here in
29th.
person or you're gonna be on video, Mr. Farrell? You
Yes,
wanna
I
play
will.
this little game with me?
No, I'm
You
not
feel
playing a
free. I'll
game,
see you
sir.
September 29th. Mute him.
Yep.
Faraz Cortez Sharp, 24.
Oh, happy Monday once again, everybody. Welcome to the Courtroom Files Live. Lindsay says it in the chat. Ha, ha, ha. There it is. Yep. There it is indeed. We'll keep an eye on Judge McNally for sure. I've got eyes on a lot of courtrooms this morning. There's a decent amount going on. Reportedly, Mr. Magoo is supposed to be in Judge Washington's court this morning, though I haven't seen that yet. So we'll keep an eye there. Judge Stevens is running. Let's go to Judge West, though. Her fashion show is underway. Let's see what's going on.
Are you David Kalina? And Mr. Kalina is charged with injury to a child, elderly, or disabled individual, and what is the announcement?
I believe, I got an email from Ashley toward the end. She's, I sent her some stuff to bring to Mr. Knopf about a pretrial diversion.
Okay,
And she told me she likely wouldn't have
that
a
done by,
response today.
sure.
So,
Okay, so what I'll do is reset it a normal reset's about 30 days
That's
to
fine.
maybe get it in front of him.
Okay.
And then we'll see where y'all are at the next court date.
Sounds great.
Stay in touch with Mr. Cat. He'll let you know when you need to be back. All right, you're free to go.
Thank you.
Thank you.
Good to see you.
You too, sir. See, is Mr. Comerford here?
Mr. Coleman's here.
Thank you. Let's see, Aaron Roberts, that's sentencing. No problem, I know you have plenty to do. Good morning, Mr. Coleman.
Apologize.
That's okay, we were actually running a little early this morning, which is kind of rare.
I believe my claimant in this case, Mr. Mason, my colleague may be here. I may have to call his name. If I could just call
Yeah, of course.
Mason McCall.
Goodness. Just get some stuff moving. All right, sir, you are Aaron Roberts, and this is 25 DCCR 0250, and Mr. Roberts was previously in court, entered a plea of guilty to the state jail felony offense of theft of property, And I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Defense has your,
State has, Judge.
Are there any additions or corrections?
none from defense.
Not from the state.
And so the agreement was for a 5-year probation, restitution in the amount of $33,204.98. There was a disagreement as to the type of probation that was going to be left up to the court. Is that correct?
Yes, Your
It is your.
All right, let's go ahead and Mr. Lane, you may proceed.
Your Honor, we're asking the court to defer all proceedings for 5 years and place Mr. Roberts on probation and to order the $33,000 in restitution. He was working for about 10 months. He worked for about a year with this company, if I'm not mistaken, but for about 10 months, there was no stealing at all. I believe he started in August 2023. He had a child who was born with respiratory problems. The insurance company was not paying everything, so back in June of 2024, the bills started rolling in, and then he started embezzling from the company, which he confessed to once confronted. He has pled guilty. He is remorseful about this, and today he was going to come as best he could with $2,000 as restitution to show good faith, but about a month ago, he lost his job. Apparently, they're watching YouTube, but he has now gotten another job in Winnie, getting paid $19 an hour. The state's probably going to argue that he's gotten a chance on deferred before in 2010. That was 17 years ago. He did successfully complete that. And I think with the felony conviction, as the court well knows, it's much harder to obtain employment. He has disclosed this case to his new job in Winnie. I'm told that they have not made a decision. He's working, but it could affect him. He does have the willingness and the ability to pay the $33,000 back. The court always will have the opportunity to, if he doesn't comply, to revoke his probation, given he has no juvenile history, no misdemeanor history. He gets his child, 2-year-old child, every weekend. Type 2 diabetes, but he can do it. And I don't know if loss prevention with the company has actually paid any insurance claim. And I know Mr. Roberts would like to address the court as well.
All right, go ahead, sir.
Like I said, I'm remorseful for what I've done, so I'm just trying to do all I can to pay back what I owe.
You know, on a 5-year probation, with my quick math, and I always joke about not being good at math, but that's $500 a month minimum to try to get this paid back. Mr. Coleman?
I'll be brief, Judge. Mr. Lane essentially made my argument for me. This is not this defendant's first run-in with the law. In fact, on a felony, a previous felony, he received 5 years deferred. He should have known, of all people with that deferred, having had that chance, that to engage in this activity, this felony activity, very well could result in him possibly going to prison, let alone being on a post-conviction straight probation, Judge. The victim here, the complainant from the company that he stole from is here if you want to hear directly from him how this negatively impacted that company. But Judge, people every day in everyday life have issues and financial issues that they deal with, and they don't resort to stealing more than $33,000 from their employer. I'm asking the court to put this defendant on a straight probation. Thank you, Judge.
Thank you, Mr. Coleman. And I appreciate the victim being here wherever they are.
Frank? Jamarian Martin?
You know, so Mr. Roberts, Mr. Coleman is correct. You did have an opportunity at a probation back in 2010. Looks like you were successful and you have stayed out of trouble since then. I really want this money as much as possible paid back. And my thought is probably the best way for that to happen is for a deferred probation so that you can hopefully try to keep some decent job, because it's true that a conviction is going to change all that. But here's, so I do want you to understand though, well, let me do this. Here's what I'm gonna do. I'm gonna find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm not going to do that. I'm going to defer all proceedings and place you on probation for 5 years. I am not going to order a fine. I am going to order that you pay the restitution in the amount of $33,204.98. This is going to be a zero tolerance probation. You are going to be required to make some payment every single month towards this restitution. Even if it's not the full amount each month, there better be something being paid. What can happen is you can go this whole probation, and a lot of people think, well, I'm going to wait for my tax refund, or I'm going to wait on whatever it is. I'm going to sell something next year, and they think they're going to get caught up at the end. And what can happen is if you do that and you come back in front of me on a motion to revoke, and I find that you could have paid some of the restitution and you didn't, you could have done every other thing right on your probation and still go to prison in 5 years. So you need to pay as much as possible. Every tax refund you get will go towards this restitution. You'll be required to give probation all of that documentation so that you can pay as much as you can every single month, and then each year there's going to be that payment as well. You'll be required to do community service and follow all of the other rules and conditions of probation. Obviously, you know this is an excellent opportunity because this conviction's not on your record. The other side of that, though, any violation, you're back in here, you're convicted. Mr. Coleman will be reminding me what he argued today, and you'll likely be going to prison for up to 2 years. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed. So you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good luck, sir. Thank you, Mr. Lane. Thank you, Mr. Lane.
Okie dokie, let's keep an eye on Judge West. We'll be back later. In the meantime, let's go to Florida. Wade Mercer doing his Monday thing.
¿Usted me ve y me escucha?
Sí, sí, señor.
He can hear me and see me, Your Honor.
Mr. Perez, good morning. You're here because, thank you. Mr. Perez, you're here because you've been accused of one count of failure to appear in case 24-274
Señor Pérez, usted está aquí porque no compareció a una audiencia en la causa 24-274 MM.
It looks like you posted a cash bond in Jackson County and you had a hold from the United States Immigration Service.
Parece que usted pagó una fianza en efectivo en el condado Jackson y tenía una orden de retención de parte del Servicio de Inmigración de Estados Unidos.
And then very recently you were picked up in Holmes County on this old warrant.
Y recientemente lo recogieron en el condado Holmes por esta orden de arresto vieja.
Mr. Perez, the warrant that's issued right now has no bond set on it.
Señor Pérez, la orden de arresto en este momento no tiene ninguna fianza.
But I don't know when you got out of immigration custody.
Pero yo no sé cuándo usted salió de la custodia de inmigración.
Mr. McDaniel, I don't want to ask him if he was deported or not because I don't want to put in position of admitting to another crime, but that may affect the no bond. Do you have any additional information or have you been able to communicate with him, Mr. McDaniel?
He was not deported.
Señor McDaniel, yo no le quiero preguntar a él si lo deportaron porque eso pudiera conllevar a que admita un delito. ¿Tiene usted alguna otra información? A él no lo deportaron.
When I spoke with him, he said that he was stayed in ICE custody for 2 or 3 months, which would have been beyond the court date. I know when I look at it.
Sí, cuando hablé con él me dijo que estuvo bajo la custodia de inmigración por unos 2 o 3 meses, lo cual va más allá de la fecha de su audiencia cuando yo lo veo.
Mr. Perez, given that this warrant's been out for you for over a year, I'm going to continue the no bond hold.
Señor Pérez, siendo que esta orden de arresto ha estado pendiente por más de un año, yo voy a continuar con la orden de detención sin fianza.
based upon your criminal history, if you'd like to resolve the case today, the offer being made to you is 6 months in the county jail.
Debido a sus antecedentes penales, si quieres resolver su caso hoy, el acuerdo que se le está ofreciendo son 6 meses en la cárcel del condado.
If you not want to accept that, that's perfectly okay. I'd be glad to schedule you for another court date.
Si no quiere aceptar eso, está muy bien. Con mucho gusto lo programo para la fecha de otra audiencia.
Do you have any questions?
¿Tiene alguna pregunta?
Sí, no quiero aceptarle eso.
Yeah, I
No
don't
quiero
wanna-
aceptarlo, eso es mucho tiempo porque no hice nada.
No, I don't want to accept that. I don't want to accept that. It's too long. I didn't do anything.
Okay. Mr. McDaniel, what court date would you like?
O si él me lleva con la migración, pues con mucho gusto yo puedo pagarlo y no vuelva otra vez aquí en Estados Unidos. Yo no puedo estar aquí en Estados Unidos, yo no vuelvo nunca. Y si él me pone una fianza, pagarla, que me lleve la migración y jamás volveré aquí en Estados Unidos. Voy a salir de este país, voy a estar en mi país.
Or if he takes me to immigration, it's okay. If I get deported, I'm never coming back to the United States. I can't be in this country. I'll never come back. So if he gives me a bond and I pay it, they can take me. I'll never come back to the U.S.
Well, according to the paperwork I've got, you've been removed at least 3 times, so I'm not letting you out this time.
De acuerdo con el papeleo que yo tengo, a usted se le ha sacado por lo menos 3 veces, así que esta vez no lo voy a dejar salir.
So we're going to see you at your next court date. Un momento, por favor. We're going to see you at your next court date.
Lo vamos a ver en la fecha de su próxima audiencia.
And Mr. McDaniel, when would you like him scheduled for?
Next jail arraignment date is fine.
¿Para cuándo lo programamos, señor McDaniel? Para la próxima lectura de cargos desde la cárcel.
October the 8th at 9 a.m.
El 8 de octubre a las 9 a.m.
Sí,
Now, do you have any questions?
yo quiero que me perdona esta vez, pues la otra vez nunca vuelva a hacerlo y yo quiero que me lleven en mi país o hay una voluntaria, yo pueda irme, yo no volveré nunca, nomás estoy aquí porque mi mamá está enferma, mi papá ya está muy anciano y mis hijos están aquí y por eso estoy luchando aquí, no por gusto, siempre estoy en una lucha de una situación grande y si mi mamá ya está está hospitalizado y está para morirlo y yo necesito a ella, siempre mandaba dinero para curarlo a ella y por eso estoy en una lucha aquí. Y que me perdonan y que si me da chance de salir, que me lleva a Guatemala, pues mucho gusto y no volveré jamás nunca aquí en Estados Unidos. Voy a estar con mi mamá, con mi papá, aunque descase el dinero, pues ni modo. Me necesita mi mamá en Guatemala.
And Your Honor, the interpreter will not be able to interpret everything the defendant said, but I would like to ask for forgiveness. This time, I'll never do it again. My mom is very sick, and my dad is elderly. My children are here. That's why I'm in this country. I'm not here just for any reason. Just always battling. My mom is at the hospital near death now. So if I get deported to Guatemala, I want to be by her side and I can stay there even if money is short.
You have no bond. You've been deported 3 times. We'll see you at your next court date, sir. Have a good day.
No tiene fianza, señor. Lo han deportado 3 veces. Lo veremos en la fecha de su próxima audiencia.
¿Para cuándo ese dice? 8 qué?
And when was that? 8 what?
October 8th.
El
October
8 de
8th.
octubre. 8 de octubre.
Sí, ojalá que me da oportunidad que me baja el tiempo. Quiere que estar con mi mamá porque ya está para morir. Quiere ver a ella que se muere, pues somos humanos, queremos la mamá, queremos familia, pues.
Okay, well, I hope you reduce that time. I mean, I want to see my mom. She's about to die. We're humans. I just want to be there with her.
We'll see you October 8th. Have a good day, sir.
Lo veremos el 8 de octubre.
Gracias.
Que tenga buen día, señor.
Gracias.
Next we have, thank you, Mr. Ricardo. Appreciate it, sir.
Yes, sir. Thank you, Your Honor.
Yes, sir. Next we have Nicholas Eubanks. I didn't sign it yet. I wanted to see what happens first. Mr. Eubanks, good morning. Mr. Eubanks, you're here for first appearance accused of one count of resisting an officer without violence and one count of possession of drug paraphernalia. You've also been accused of violating the terms of your probation based upon the new arrest. I read the complaint and I want to hear from the state and defense on probable cause and other issues before making a decision on the bond revocation, whether or not the bond revocation, the violation of probation warrant. So Mr. McDaniel, anything on behalf of Mr. Eubanks?
Well, Your Honor, he's on, conditional release and PTI. When I read the complaint, I didn't see any probable cause. I don't know if the police can actually go into their house and then detain them in their house, inside their house, because essentially he said some derogatory remarks to one of the officers. It does not really pass the smell test, but with him being on the PTI and the conditional release, I completely understand
Here's my question, Mr. McDaniel, Mr. Mitchell. So when I read the complaint, there's a reference to an identical twin brother. Mr. McDaniel, is it your understanding he actually has an identical twin brother, or is that something that's fictional?
He's got a twin brother.
So it looks like the officers put the burden on him to prove he wasn't the brother. They were there looking for the brother. They have a warrant for the brother, and they put the burden on Mr. Eubanks to show us that you're not your brother. And I don't know that that's appropriate. I don't know that they can put that. I think they got the right to investigate it and possibly detain him until they verify he's not the twin. But the language in the complaint is concerning, so it's just an unusual fact pattern. So here's what the complaint says, Mr. Mitchell. Nicholas was asked where his brother was and that he would need to dispel our suspicions that he was not Michael Eubanks due to having no differing identifying traits. And I don't know that he needs to dispel anything. I don't know that in the United States, that's not his burden to disprove he's not who he is. It's law enforcement's burden to prove he is the person they're looking for. So that raises an issue in my mind. The second concern I have is then they allegedly found drug props with drug residue in them on his person, and he's on conditional release. So if it was a probation officer doing the search, I'm confident that it would be admissible in the VOP, but it couldn't lead to a new charge. This is not a probation officer doing the search. It's a law enforcement officer, so it's just a really unusual fact pattern. That's why I haven't signed the VOP warrant. I wanted to hear from both sides before I decided whether or not violation of VOP, violation of conditional release warrant, that is. So, Mr. Mitchell, what's the state's position?
My position was, it just looked like, I feel like if anything, I'm looking at it right quick.
If the state's willing to, I'm just going to suggest that the state dismiss those new charges and he do 30 days on the petty theft. I don't think that case is, I thought I had my issues with it, but
I have no problem with that.
I think the officers got the right to detain him until they verify his identity, but putting the burden on him to prove, I think that's probably a violation of due process. They can't require him to prove anything. It's their job to prove it. It's not his, but sounds like y'all may have reached an agreement. So Mr. Eubanks, you may be off PTI. Listen to Mr. McDaniel, and we'll see if this is what you want to do, sir.
Your Honor, in 25-416 he's going to admit that he's going to go ahead and plead no contest to the charge of petty theft. The understanding he'll be sentenced to 30 days in the county jail. He'll have 1 day jail credit, be a $370 or whatever the fine is remaining on the case, probably the entire amount, and whatever the restitution is will be owed. There'll be a civil judgment if you don't get it worked off while he's at the jail. The restitution he'll have to pay at the clerk's office. I think it was less than $10. We'd ask the court to consider withholding adjudication. He doesn't have anything, but that's.
Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor. And once we get a official case number for these new charges right here, I'll dismiss as a companion plea to the violation of, or well, to the petty theft.
Mr. Eubanks, did you hear all that, sir?
Yes, sir.
Do you have any questions about any of that, Mr. Eubanks?
No, sir.
And sir, is that the plea you would like to enter on that old case with the understanding the state's going to dismiss the new charges based upon the jail sentence?
Yes, sir.
Mr. Eubanks, I'm going to accept your plea of no contest to the original charge of petty theft. I'm going to withhold adjudication of guilt. In that case, I'm going to sentence you to 30 days in jail, give you credit for the time that you've already served on that case, or all the time you served total. And that is how much, Stone?
He was in jail one day previously on the petty theft, so
he would have at least.
Oh, so 3 days.
Yeah, 3 days.
3 days credit, court costs and fines remaining, Mr. Goodson.
There's a $370 court cost and $69.87 restitution. May I ask a question when you get through?
Sure, go ahead.
So are we going to pursue the violation, or is he just?
He's entering a plea, so I'm not signing the warrant because it's just going. There's no point in putting that warrant in the system.
Thank you, sir.
He's just going to enter a plea on that case, and we'll put the disposition in the system. And Mr. Mitchell's agreeing to dismiss the new case. So the sentence is 30 days. So you're going to be off the supervision. You're going to have that behind you. You don't have any convictions or anything from yesterday. And I'm continuing the withhold of adjudication because you had no prior history when you got the charge you're on supervision for. Mr. Eubanks, do you have any questions about any of that?
No, sir.
So is it, I'm curious, the case is over. I am curious though. The complaint says that when they were trying to determine whether it was you or your brother, they asked about tattoos and that you and your brother supposedly have the exact same tattoo also. Is that accurate?
Yes, sir.
So you're identical twins and even have the same tattoo, right?
Yes, sir.
Wow. Mr. Eubanks, do you have any questions?
No, sir.
All right. When you finish this sentence, there's no probation to follow, sir. You finish this sentence. This is all behind you and over with. No more supervision. Okay.
Yes, sir.
I wish you the best.
That's commitment.
I believe next is Isaiah Oliver. Corporal Drown. I've got Mr. Oliver's name spelled a couple different ways. Mr. Oliver, good morning. Mr. Oliver, I need to make sure we've got your name spelled right. How do you spell your first name, sir?
ISAIAH.
Thank you. So Corporal Drown, the jail sheet does not match the first appearance sheet, and it does not match the booking sheet. So Mr. Oliver, I'll ask the jail to get that straight. But Mr. Oliver, you're here to see if Bay County did anything on the violation of probation that you have, potential violation of probation you have down there. And I did see a warrant. Judge Garcia has signed a no bond warrant for Bay County in 22-2258. What that means, Mr. Oliver, is if you post bond in Jackson County, you'll go to Bay County and deal with that. If you don't post bond in Jackson County, you will deal with Jackson County first, and then you'll deal with Bay County at a later date. But you do have a no bond warrant out of Bay County. Any questions, sir?
No, sir.
All right, sir. Wish you the best. All right. We have Charles Smith and Mr. McDaniel. I think your text said he was just going to try to post a bond that had been set for him over the weekend.
Correct.
Michael Hamilton. Mr. Hamilton, good morning. You're here because you were first appeared this weekend for driving with no valid driver's license. Mr. Hamilton, I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel, your attorney.
All right, may I ask you a question, Judge?
Let your attorney say what he wants to say for you on your behalf, and talk to him off the record. And I'm glad to try to answer your question if it's something I can answer.
Okay, hey, Judge Mercer. Is there any way I can get probation on this? I take care of an elderly lady named Cynthia LeBee. And that's originally why I got caught driving without a license, because I knew it was wrong, sir. I positively know it was wrong, but I went to go fill up her tank so she could move in the morning. I don't normally drive, and it was like kind of late, and she needed to go in the morning, and she ain't got no legs, so she can't get out and fill up her tank. So that's what I went to go do for her. I stopped for the officers. You can look at my record. I usually run if I'm in trouble. I have been out of trouble. I've stayed out of trouble. I am trying to do right, and I think I could do probation, Mr. Mercer.
You stayed out of trouble for how long?
I've been out of trouble for, since I went to prison, I haven't been in no trouble. I
Ask you a
think
question.
about
Let me interrupt
5
you.
years.
Let me ask you a question.
About 5 years.
Before you
about
answer the
5 years.
question, before you answer my question, I'm looking at your criminal history.
Oh, yeah, I had a
So
trespass.
my question was, how long has it been since you've been in trouble?
About a year.
No.
It's about the trespass. I had a trespass and a probation violation for the trespass. But
March 21st, 2025, less than 6 months ago.
Well, sir, that was just the trespass. I wasn't, the trespass, if I could explain the logistics of the trespass, you would understand.
It's not the trespass is the reason. The trespass is not the reason you're getting the offer. This is the reason you got the offer that you got. It's probably 20 arrests in there. So your chances of me giving you probation is 0 based upon your criminal history.
Or the complaint also made mention that he.
Your Honor, I
Go
thought
ahead,
Mr.
Joe.
Hamilton, he's going to enter a plea of no contest to the charges listed. You understand he's going to be sentenced to 60 days in the county jail. They have 1 day jail credit. There'd be a $400 fine, which would be a civil judgment unless he works it off while he's at the jail. He has signed his plea waiver form, waives his right to jury trial and call witnesses.
Thank you. Mr. Mitchell's that agreeable with the state?
It is, Your Honor. And I was just saying that the complaint made mention that when he was pulled over and arrested, he possessed marijuana and needles also. So the state would have been objecting to probation based on his history and the facts of the case right there. So this offer that the court has made is agreeable with the state.
So, Mr. Hamilton, if your history were different, or if it'd been longer since your last arrest, it'd be a different story. But Mr. Hamilton, you know, what I have is what I have. And if that's accurate, that's the basis for what I'm doing, what I've approved. Mr. Hamilton, is this a plea you would like to enter, sir?
Yes, sir.
Mr. Hamilton, I'm going to accept your plea of no contest, no valid driver's license, driving with no valid driver's license. The judge you guilty, sentence you to 60 days in jail. Give you credit for 1 day you've served, $400 court costs and fines imposed. There'll be a civil judgment if you don't get them worked off. Mr. Hamilton, I'm hoping you get in that trustee program at the jail and get you some extra gain time and get out quite a bit earlier. But as far as probation, there's no supervision in this case. You finished the jail sentence. This is all over with. I do wish you the best. Do you have any questions?
No, sir.
Have a good day,
Today's my
sir.
birthday too.
I wish you happy birthday, sir.
Is it 1 day credit, or is he a return from the weekend?
He was a return, so it'd be at least 2 days.
At least 2 days. Okay.
Mr. McDaniel, is it 2 days or is it more than 2?
It's 1 day. He actually got arrested at like 12:30 in the morning.
okay.
So yesterday, so it'd be 1 day credit.
And the jail will give him credit for today. Thank you.
Okay.
Mr. McDaniel, that's everything I had on my first appearance list. Anything else from the public defender's office?
No, Your Honor.
Corporal Drown, anything else from the jail?
No, Your Honor.
And Mr. Mitchell from the state?
Another from the state, Your Honor.
All right, thank you, Dolman.
Wish me happy birthday, Judge. I love it. Oh, let's do something fun. Let's go to Judge Oakley. He did 30 minutes earlier this morning. Let's see what kind of fun he was having.
Fraction. It's $560, fines and costs. I'm not going to order a work program for you because I don't want you driving in from Indiana 4 days. So I'm going to have you do 30 hours community service. That means find someplace close to home that's a nonprofit charity registered with the IRS, church, soup kitchen, Salvation Army, something like that. Volunteer with them, get documentation that you've done 30 hours and make sure I've got that paperwork between now and December 1. Got that?
Yeah.
Charity work. All right. As to the 560, go downstairs, add that. What's that?
560.
Plus the ticket. That's why I reduced today's fines and costs. Go downstairs and work out some kind of payment plan with them. Questions? No questions? I'll take that as a no.
No question.
Is it Carlton Braxton? Come on up. Are you going forward today without an attorney? All right, it says here that you're going to plead guilty to no valid operator's license on person and plead responsible to double parking. If you do that, the prosecutor wants me to dismiss both the charges issued on August 11th. Is that your deal? All right. Did you read your rights form? Yeah. Did you understand your rights? Did you understand the possible options you have because of your rights? And do you understand the possible penalty on the no ops? Understanding all that, are you pleading guilty to that charge freely and voluntarily? Did you drive a vehicle on that date in Romulus? Was your license suspended, revoked, or no? Was your license invalid at that time? Invalid or improper? That's pretty invalid. All right. I will accept your plea to the added charge. I'm not going to take the plea from you to double parking. That just causes extra work for her. The idea behind that with the prosecutor, so we can get a little extra money out of your pocket, I'll just hit you a little harder on the misdemeanor. Understood? To you, it doesn't matter. To the clerks, it's one less file to transfer. All right, what's the status of your license? You got it back? Awesome. Awesome. You're working? Where at? What do they do?
Demolition.
Okay, how long you been with the company? Good, good. Full-time plus probably. Yeah, good. Okay. Anything else you want me to consider, sir? Okay. All right, on your file, fines that cost $700, 3 days on the court work program. You sat in here, heard me explain how that worked. Do you have any questions? All right, can you pay the 7 today or do you need options? Go downstairs and you get all those where you sign up for your work program. Have a lovely day. Good luck on that new job. Brittany, is it Mexstroth? Mexstroth. You are going forward today without an attorney? All right, you made a deal with the prosecutor though. Did you read your rights form and understand those rights and options? You understand the possible penalty for the added charge? Up to $500 fines plus court costs and up to 90 days in jail. Understanding all that, are you pleading guilty freely and voluntarily today? Did you drive a vehicle in Romulus on May 19, 2021 while your license was suspended, revoked, or denied? I'll accept your plea to the added charge, dismiss the original charge. What's the status of your license now? Great. Are you working? Okay. No work there, right? How many kids? Yeah, no work. Just don't get paid with money, right? All right. Anything else you want me to consider? How old's your youngest?
She's 7.
7? I'm going to give you the option. I'll let you do 3 days on the work program, which is easier because you don't have to give it any thought. You just go down there and pick 3 days, you show up, you do what you're told that day and you're done. Or I'll let you do some community service hours. And if you're inventive, you can find some place where you can probably take a couple of the kids with you and they think they're having fun, but you're volunteering somewhere and getting some hours. What do you want? The hours? All right, I'm going to do 40 hours community service. And if I give you till December 1, plenty of time. Fines and costs are $500. Can you do that today or do you need options there too? Go downstairs and talk about options. We've got a list. We can provide a list of agencies that are pre-approved in our area. You don't have to use those agencies. That'll just help you find some charities. All right. Ask for that at the counter too. Enjoy your day. Thank you. Lance Singleton. Mr. Singleton, are you going forward today without an attorney? Let me look at this deal you made. All right, same deal with you. You're supposed to plead responsible to a double parking so I can get some money out of you. All right, with you, if I don't have a third file to deal with, we just hit you a little harder on the no valid operator's license on person charge. All right. Did you read your rights form today? Did you understand those rights and the options presented? And do you understand the possible penalty for the charge of no valid operator's license on person? Understanding that, Mr. Singleton, are you pleading guilty to that charge today freely and voluntarily? All right, was your license suspended, revoked, or denied when you drove that vehicle in Romulus on August 11th? I'll accept your plea to the no valid operator's license on person. Both your civil infractions are dismissed, and so is your original drove while license suspended misdemeanor. What's the status of your license today? What do you have to do to get it back? How much money? Yeah. Are you anywhere near, can you see the light at the end of the tunnel, or is it still just a glimmer? Any idea when you'll have it all?
I'm not working very much. I got my cousin, I can bring it to me.
Okay. Ah, it's a tough gig, man. Yeah, good luck. Yeah, it's tough. It's tough on the caregiver. Yeah. Best case scenario, when do you think you'll have your license reinstated?
I'm trying to get it, this year because I want to try to get back to working. So, I'm looking before December.
Okay.
Definitely trying to get my license this year.
All right, so you've been sitting in here long enough to hear me sentence a bunch of people on this, right? You've been paying attention? Okay. So normally, because of the deal you made with the prosecutor on that extra ticket that I didn't do, normally it's $500 for a DWS charge pled down to a no valid ops charge. Plus, in this case, extra for the other one. What I'm going to do with you, and I'm just trying to give you an extra incentive to try to get things done quicker. So I'm going to charge you the 4 days on the work program. You schedule that whenever you can schedule it. That's an alternative to jail. Money wise, I'm going to charge you $730. But if you show me a valid license between now and November 15th, I'll waive $500 of that.
Oh.
So I'm paying you $500 to go get your license straight. Got that?
Right.
All right. So the total is $730.
License 5, what date?
November 15, and we'll waive $500 of the $730. So what you want to do is you go downstairs, get some kind of payment plan, get $230 paid, come in with your license, you're done with that. All right? Schedule your work days and you'll be done long before November. Okay? Got it? Questions?
No.
Okay, good luck. And brother, good luck with your mom. Tanika Carter. Ms. Carter, are you going forward today without benefit of a court-appointed attorney? You met with the prosecutor and you made a deal. Did you read your rights form? You understand those rights and the options those rights give you? You understand the possible penalty for the added charge? Are you pleading guilty to that charge today? Freely and voluntarily? Did you drive a vehicle in Romulus on a date of April 11, 2025? And at that time, was your license invalid? Suspended? All right. You're valid now, though. Good for you. I'll accept your plea to the added charge and dismiss the original. Are you working? Laid off by who? What kind of system? Coding systems. How long you been with the company? How long you been with the company? Okay. And you said you're laid off until when? Okay. Is that like a seasonal thing they do? All right. Anything else you want me to consider be our, oh, you got money already, or we got money of yours. All right. That'll apply. Anything else you want me to consider before I sentence you? All right, so the total fines and costs on this file, because we got a show cause fee and a bench warrant, is $600. We'll apply your $150, so that leaves a balance of $450. Can you pay that today? Talk about options downstairs. I'm ordering 3 days on the work program as an alternative to jail. And you were in here, but any questions? You sure? All right, good luck. Good morning, Mr. Bowditch. Catherine Cipollone, how do you say it? Come on up. I'm sorry.
She needs to be addressed, I guess it was a dismissal. Jesus, we can't even read it.
Morning, Your Honor, for the record, Jeffrey Alex, appearing on behalf of and with Ms. Cipollone. Could you tell her your name for the record, please?
Catherine said morning.
Good morning.
Prosecutor wishes this matter be held over.
Yeah. All right, I will dismiss this without prejudice. She made a note here. It says you need to let the New Boston schools where your new address is. Let them know. Got it? You're welcome. Derek William.
Appearing on behalf of with Mr. Williams is approaching.
Would you waive formal reading on Mr. Williams' behalf?
Standing.
I will enter a not guilty plea.
Discovery. We're looking at October 16th at 10:30 if it's appropriate.
Who's that with, Heather?
Driver's case, correct?
I think.
Yes.
Yeah, Judge Martin, right.
All right, Mr. Williams, we're gonna get you a notice for that court date. In the meantime, I'm gonna put you on a personal bond. First two conditions are pretty obvious. Stay out of trouble and participate in your court date. The third one is do not purchase, possess, or consume any mood altering substance unless you got a doctor's prescription. That means no alcohol or marijuana. Can you live with those rules? Oh, you have a choice. Yeah, not a good one, but you got a choice. Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw up? Any questions? Just have a seat back there. We'll get you a written notice.
Your Honor, Mr. Trustee.
Got it. William Petrowski. How do you say it? Good morning.
Your Honor, for the record, Jeff Scott, appearing on behalf of the defendant. Sir, could you tell Judge your name for the record, please? William Trust.
Thank you.
Your Honor, today's date I have set for bringing in this matter with full brief, so we also have chance to pre-traffic. We have an excellent agreement in which Mr. Trustee plead guilty to an hand-count allowance. Driving the vehicle, with the understanding the original charge would be the distance.
All right, sir, did you discuss your rights with Mr. Bowditch? You understood those rights and the options they give you? And do you understand the possible penalty for the charge?
Yes.
Understanding all of that, are you pleading guilty freely and voluntarily today to that charge? All right, did you drive a vehicle January 6, 2024 in Romulus? Were you suspended, revoked, or denied at the time? I'll accept your plea to allowing an unlicensed driver to operate. I'll dismiss the drove while license suspended charge. Before I sentence you, just a reminder, it looks like you got two cases coming up on the 18th with Judge Patton on Zoom. You know about those? Okay. You're welcome. Still suspended? All right. Are you working? Where do you work? How long?
10 years.
Okay. All right. Anything else you want me to consider before I sentence you? Ready? All right. All right, Mr. Petrowski, I'm gonna set fines and costs at $615. We do have a $150 bond that will apply towards that balance. I'm ordering 4 days on the court work program. I'm not sure if you were in here or not. Work program is an alternative to jail. You pick which 4 days you want to work. You walk out of here today with a schedule. Those days you're scheduled, you have to be back here at 8 o'clock in the morning. Understood? What are they?
I just need to get going whenever I get somewhere. Once I sit down, it gets stiff and I'm gonna.
We don't sit much. Yeah, I don't think you'll have problems. If you're having problems, I don't want you to injure yourself. All right. Make sure you got his phone number. If you're having any issues, you can call him. He'll know how to get you in front of me so we can talk about it. Okay. As far as the money, can you pay that today or you need some talk about that downstairs? Any questions? Now, when you come back on the 18th, you may or may not talk with him, right? Let the other attorney know what happened today. They'll talk to the prosecutor about that. You might get a little sweeter deal. And certainly when you're talking to the judge before sentencing, you can let her know that you're doing work program for me. Okay? Good luck.
That's what he was just.
Oh, great minds think alike. All right. Good luck. Good luck. You're welcome. Amani, is it Ginyard?
Radio.
Did I say it right? Ginyard? Ginyard. I had a 50-50 chance on that G. Mr. Bowditch, your parents?
You're on fourth grade. Figuring out the half of it is Ginyard.
No, Amani Ginyard?
Thank you, ma'am. You're on case date. Rating experiment for a big study. Yeah, can't see three times. You can hardly have executed complete agreement. Subject to courtroom with that agreement is Ginyard going to plead guilty to the charge violating parental responsibility. With the understanding that would be taken under 7 months for a period of 12 months.
Who's the problem child, son or daughter?
Not a problem. This.
It's not a,
It's at mid 4 days of kindergarten. I'm not even sure kindergarten required, but she missed this little baby missed 4 days of kindergarten primarily because of busing issues.
okay.
And vehicle issues at home. But she's in kindergarten now, correct?
Yeah. What's your daughter's name? Thank you.
So far, she's doing this 2 days, and once again, it was last week because of busing.
Transportation straightened out now. Okay.
This is not trouble.
All right. All right. So you understand how this works? Mr. Bowditch, explain how this works. I'm going to delay sentence on this. I think the term was 12 months.
Yes, sir.
I'm going to delay sentence on this for 12 months. You don't go out and commit any crimes and no further problems with attendance with a bond. As long as that happens at the end of that 12 months, this gets dismissed. Understood? All right. I don't assess any court costs on these. All right. Questions? You all set?
Remind me, I have to talk to, the prosecutor about some other Huron former responsibility because there was.
Marcus Fuller.
Josh,
Good morning.
Your Honor, we're here for today's show cause in this matter. Mr. Board has posted a bond, so I don't think there's any warrants to address.
Nope.
Simply looking to get a schedule to pay out in the pre-trial date of October 16th. Make no things in discovery. And do not think people are really ready to discuss any plea at this.
What time are we going to do the 16th, Heather?
10.
And that's with
Judge
Martin? All right, so that's by Zoom. Bond will be continued. You have a seat, we'll get you a written notice. But before you walk away, I want to remind you, you owe us money on a speeding ticket. You know about that one? All right, it looks like it was a Romulus speeding ticket. I wonder if you got it at the same time you got this.
This one I think got March 23.
Yeah.
Yeah, and I don't have an appearance ticket, so I don't know. Can you tell me that, Heather?
Which? Yes, it was on the same.
So on March 27th, when the drinking and driving charge came up, they also ticketed you for a speeding ticket. The speeding ticket is a civil infraction, so if we didn't hear from you within 14 days, it automatically went on your record and you started owing money. Understood?
So that's what he's saying, so we need to be given additional safety. Your Honor, it wasn't a roadside stop, it's in there was an accident involved in this one.
I don't know.
Yeah, I just want to say,
Yeah.
so you can get a civil infraction like a speeding ticket, on the say that you have to contact for 14 days.
And they may have mailed it to him. I don't know.
We'll have to figure out that discovery, the next year and get it before.
Just set the speeding ticket for a review on October 16th. And then by that point, you'll know what happened. You can have some conversation with Judge Martin. Right. Just have a seat.
Soon, October 16th. Or,
Kayla Bowman. Same date. Bachman. Well, that's kind of her fault because she's pronouncing that GH with like a K. I mean, you can do that.
You got a mom in here.
I don't care how you pronounce it, but you know,
So.
you probably get that mispronunciation all the time. Yeah.
Like Stockman, Turner, over.
Yeah, yeah. Go ahead.
We'll waive the full review arraignment. We're gonna ask the court to plead not guilty.
Done.
That's the bond, right? We asked the court to issue a personal bond in this matter. They have no issues that she's going to be appearing in the future. Does have mother present up for here.
Yep.
Safely. We're looking to have a date of the 16th.
Yep.
This has got a little bit of an interplay between Florida and Michigan. We're trying to get answers as to what a possible resolution in Michigan would mean with the parts.
Right, right. So did she have a Florida license at some point or what?
Does and did, or that's where.
Yeah, that's what you're trying to figure out.
She has a valid license right now.
Okay.
Michigan issued the paper temporary. Well, what we're unaware of would be what with the prospective plea.
What'll it do?
God, result in 60-day restriction.
Yep.
We don't know if Florida's actually gonna honor that.
Right.
Automatic suspension.
Right,
So we're
right.
trying to kind of look the real.
Makes sense. Okay. So pretrial, October 16th, 10:10 in the morning by Zoom with Judge Martin. In the meantime, I'm gonna put you on a personal bond. First two conditions are pretty obvious. Stay out of trouble and participate with your court date. Second one or third one is do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. So that means no alcohol, no marijuana. Understood? Can you abide by those rules? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw up on my bond? Any questions? You're all set.
For the first, you can call if I get sorted out, I'll reach out to you. I gotta get you noticed a little late. Okay, hang on, you can read your,
I'll mention, the attorney's right there.
All right, let's change things up a little bit. We'll go to Texas. Say good morning to Judge Stevens.
Versus Christopher Caleb Watson. That's you, sir? Yes, speak out so she can take everything down. That's you,
Yes.
Christopher Watson. You're here with your attorney and the state's attorney. Mr. Adams, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about April 25th, 2023 in Jefferson County, Texas, you committed the state jail felony of burglary of the building. Do you understand fully what the indictment states?
Yes, sir.
If convicted of such a crime, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 18 months in the state jail, and will be given credit for all time served in accordance with that particular case. Do you understand?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
It's incredible.
Okay. No, that is good.
It's not right. It's not right. You're right. McKinney, it's doing something weird. Look at this right here. There you go. Y'all saw me. I tried to write it down and it wouldn't write. And then
Third time's a charm.
when are we getting the new pants again?
October.
This year?
October 1st. Well, they're gonna order them October 1st.
So if I follow this, it's incredible. I feel like I'm in the Indy 500 and I've got a Volkswagen Beetle in the race. If I follow this agreement, you have no right of appeal. Do you understand? So Again, how do you plead to this indictment, guilty or not guilty? You're pleading guilty today voluntarily and because you are guilty? Question?
Yes, sir.
I show you what's marked as State's Exhibit 1.
I got it.
Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, and indictment's been wrote to you, you've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
I will follow this agreement, sir, and I will make the findings that you are, Mr. Watson, pleading guilty voluntarily, knowingly, intelligently. You are mentally competent to be able to do that. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 here admitted to find you guilty beyond a reasonable doubt, and I so find you guilty beyond a reasonable doubt of this state jail felony. I am following this agreement. You were hereby sentenced to confinement in state jail for 18 months, and you will be given all credit for time served in accordance with this case. Do you understand what has happened to
Yes,
us? Anything else on this? That is all. Thank you.
Thank you.
Yes, sir. Hey. Hey, right there. Hey,
I haven't seen you since search.
say where? You're wrong. I'm not kidding you.
Yours is almost done updating, Judge, and I can give you. So it's good to go.
Yeah.
Who's up next? Please, anybody? At all? What's your
Bill this way.
We'll go, Jim.
Deariante, Everfield?
Let me do that. We're in the room.
There's two cases. One's going to be dismissed.
We're pleading to both, Jim.
Yes. Yeah. I must have not. Here, give me that tablet, Judge.
No, I need.
You what?
I need.
Oh, we need the file.
Yeah. Everfield.
So, one set of plea papers when I handed you that tablet.
Yeah.
If you'll
I
have
just got the murder. No.
While we're waiting on that next contestant to show up, let's go to Michigan Judge Mertz, where this is Otsego County, where justice best happens in a converted pole barn.
Okay, we're on the record of the People versus Jared Miller, file number 256837. The record should reflect Mr. Miller's present here in the courtroom today. If I could have counsel put your appearances on.
For the record, good morning, Your Honor. Mike Rowland. Good morning, Judge Larry Brown, on behalf of Mr. Miller.
All right, this is the date and time set for sentencing in this matter. Mr. Brown, did you have a chance to go through the pre-sentence report with Mr. Miller?
I did, Your Honor.
And Mr. Miller, did you have an adequate opportunity to go through that report and talk to Mr. Brown about it?
Yes, Your Honor.
Mr. Brown, are there any additions, deletions, or corrections to that report?
No, Your Honor, and no challenges to the score.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections, but we do have a victim who would like to speak.
Okay, do you have any challenges to the scoring?
No, Your Honor.
Mr. Miller, if you'll have a seat there next to your attorney. And Mr. Rolla, and the victim. Please. And right to the podium. And we got a trial in this matter. Your name was certainly put into the record during the trial as a witness. But if you could just state your name again here today.
Samantha Badgley.
And Ms. Badgley, I did have a chance to read the written victim impact statement that was submitted. What would you like to say here today?
I have something written down. Should I just?
Sure.
Okay. I'm here today to express the impact that the situation has had on my life. The financial strain caused by the theft I experienced has not only affected me, but also my child. As a single mom, I am solely responsible for supporting my family. So to address necessary repairs needed on my home, I had to take out a loan. And the burden of making these monthly payments on this loan for money that was essentially stolen from me, as well as having a roof that is still declining over time, has further strained my already limited financial resources, as well as being a constant source of stress for me. As time goes on, my roof is getting worse and I don't have funds to repair it. And the longer I wait to repair it, the more damage is done to my home. If Jared had not stolen this money from me, or even if he had given me money back, my roof would have been able to get done. But now, because there is more damage, I will have to come up with even more money to repair it. The situation has left me feeling vulnerable and overwhelmed as I strive to provide a safe and stable environment for my child. I respectfully urge the court to consider the ongoing struggles that I face because of this crime. Thank you for your time and consideration.
Thank you. Appreciate that.
Thank you.
Mr. Miller, you can come back to the podium. Mr. Rolla, is there anything that you would like to say on behalf of the people?
Yes, Your Honor, thank you. It's a first felony situation, guidelines of 0 to 5 years. There's a recommendation of 2 years probation with jail for 3 months, which would be the top of the minimum guideline range. In this particular case, as the court's well aware, the jury took 14 minutes to find the defendant guilty in this particular case. A situation where this defendant had over a year to simply perform the work he had agreed to do, that he had contracted for, and or then refund the victim's money. And we would have never been brought here before the court. The victim is Bagley, as she already indicates, a single mother. It's unfortunate that in his written statement that's attached to the PSI, this defendant tries apparently to portray himself as a victim by indicating that on August 3rd or 4th, due to, quote, lack of a crew to help me, which was likely because of cold months coming, and other jobs taking longer, he couldn't do the work. Then stated he has a 5-star rating. And quite frankly, Your Honor, people submit is evidenced by the fact in this particular case, in addition to August being a summer month, not a colder one, of course, that the defendant also in this particular case, as you recall, as the jury was told, he wanted payment not made to his company, but to himself and or in cash. No work ever being done, no supplies ever being delivered to the victim. And then when the victim, as you recall, that she testified to, tried to make arrangements to get this done, he just ghosted her after that particular fact. So quite frankly, in the people's position, the defendant's actions are completely contrary to his claim that at no point did I intend to defraud anyone. But the fact that over a year has passed without this matter being remedied, and the facts as determined by the jury, I was wrong. It was 18 minutes, not 14 minutes. His own actions would seem to indicate otherwise, in which case, although this is the first felony and it's unusual, it would be the people's position that we think jail time should be imposed. Thank you, Your Honor.
Right, thank you. Mr. Brown.
Thank you, Your Honor. I did have an opportunity to speak with Mr. Miller. Firstly, I mean, I do feel bad and have sympathy for Ms. Badgley. I know what kind of a position that put her in. I spoke with Mr. Miller about that and essentially tried to have him imagine himself in that position if that had happened to him, because he does have a family. He's 28 years old, no prior criminal history at all. This is not a drug-related crime. It's not a violence-related crime. And he has 2 children who are on the spectrum, I believe, and another one on the way to be born very soon that he is desperate to see the birth of. if someone were to do that to him and he depended upon that service. And I don't really think he understood that before he looked at it from that kind of a perspective. The court will note that he has steady employment, he has steady residency. And again, this is his very first offense. In looking through this and reading the PSI, I did get a copy of his statement and go through that. He does have an 8th grade education. He dropped out of high school because he got his girlfriend pregnant. He dropped out of high school and went straight to work and tried to do the right thing by taking care of the family. There was no indication that he's bad at his job as far as his workmanship goes. But unfortunately, being skilled at something, you can be the most skilled person in the world at construction and roofing. But if you're going to run your own business, there are certain things you just got to do. And he has no business experience and does not know how to run business. I understand what he said, that at no time he intended to defraud anyone. And that may be well true in his mind. But again, nobody can read somebody's mind. The only way we can determine intent is through facts, actions, things that we can present, that a jury can see. So while he still believes and maintains that he did not intend to defraud, he does understand and can see with the evidence that was presented how a jury could look at that and say, yeah, this just does not look good. This doesn't look good. I don't think he's doing it in order to try and raise sympathy for himself or anything of that nature, Your Honor. I think it is just a lack of education, perhaps ignorance in running a business and believing that all of these things through his life experiences, the loss of his son, for one, and these are just things that maybe he even assumed somebody would have understanding about in his mind, not really looking at it from an outside point of view of what this really looks like. I don't think he's a really bad guy here. He intends on paying every penny of this back as soon as feasibly possible. I believe he might have a large portion of it today. So I would ask the court to take all those things into consideration when fashioning a sentence here. If the court does impose jail time, Your Honor, I would ask that the court consider holding it in abeyance or perhaps under a delay so that he can get out there, get to work, and get this paid on. Thank you.
Thank you. Mr. Miller, is there anything you wanted to say today?
Yeah, I just wanted to apologize. I didn't intend for any of this to happen. At the time I took the job, I thought it very well. I could get it done in a timely manner. And wasn't able to do that. So, like you said, maybe I'm a good roofer in a bad businessman, bad time management. You know, sorry for anything that's caused it.
I did read through the report, so I'm familiar with all the information in that report. That includes information about your history and your background, Mr. Miller. And also, I presided over the trial. I heard all the evidence that was presented in this case. So I'm well familiar with the facts of what happened. Certainly take all of that into consideration along with what you had to say here today. I read through your written statement as well. Ms. Badgley, I appreciate you coming back again today, making a statement here on the record. It's never easy for people to have to admit that they've been a victim of a crime. It makes them feel like maybe, you know, they did something wrong in some way. And it's certainly difficult to come up and talk about that in front of a room full of people. But I think it's really important that victims do come forward and make statements. Number one, I think hopefully it'll help you move on, the fact that you got to address this in an open court. But I also think it sets a good example for other victims to come forward and have the courage to do that. So I appreciate your statements as well. And it gives me a better insight into how this crime actually affected you in a real world kind of a way that doesn't come through necessarily on a piece of paper. So I take all of those things into consideration. I mean, Mr. Miller, you're 28 years old. You don't have any prior criminal history. I think that gives the court some reason to think that this could be an isolated incident and that through probation, you can get back on the right track and not engage in this type of behavior anymore. So I think that certainly is a mitigating circumstance here. But the nature of the crime, the circumstances, I think is concerning. I don't think you have to have a higher education. I don't think you have to be a good businessman to know that you don't take $6,000 from somebody and not do the work and not give them the money back. I mean, I don't know what you thought the ultimate outcome was going to be. You had plenty of time to pay this back, to make this right. I mean, right up to the morning of trial. And if you had a bunch of money that you could have put towards paying Ms. Badgley back, maybe we could have avoided being where you're at right now at any point during that. So I don't know what you were thinking if you just thought you were going to keep that money and nothing else would ever happen. You didn't really have and still don't have any real good reason for either not doing work or not paying her back in the amount of time that it's gone by. I don't think any of the excuses that you gave, frankly, are any reason to not have done that up to this point. I do think I got the real sense that through the trial and through your own statement that, you know, you wanted everybody to feel bad for you in some way. And clearly the real victim here is Ms. Badgley, who is struggling, who needs this repair done, who borrowed money to get it done. And she doesn't have the work done or the money. And she is certainly no better of a position to bear that burden than you are. So I really find that there's just absolutely no excuse for your actions in this case, your failure to make this right before now. And so I think that does call for a degree of punishment as well. So for all those reasons, I think the recommendation is well crafted here. It provides for a period of probation so that you're being monitored. It provides for some punishment so that you understand that this is absolutely not acceptable either as a businessman, but just as a person in the community taking money from somebody. It's just wrongful conduct, regardless of the circumstances. So it provides a degree of punishment for that and accountability for that. And I think that's very much appropriate in this case. So because we have a real victim who suffered a real loss, who continues to suffer a loss, I think that calls for, as a reason for the imposition of jail time. The court is going to follow the recommendation, sentence you to a period of probation for 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions that are listed in the report. The court is going to order that you serve 3 months in the Otsego County Jail. You do have credit for 14 days served. The court is going to order restitution in the amount of $6,750 that's payable to the Otsego County Clerk to be dispersed to Samantha Badgley. The court will order crime victims assessment of $130, a supervision fee while you're on probation of $30 per month, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost. You have the ability to seek an appeal of the sentence. Mr. Brown, if you could have Mr. Miller acknowledge the appellate rights.
Your Honor, he has signed that acknowledgement. I'm tendering that to the court.
Mr. Miller, you are remanded to the custody of the county at this time.
Okie dokie. Well, they lead him through that door out to the barnyard. Let's go back to Judge Stevens. He's got his next contestant lined up now.
versus Dariante Calvin Everfield. That is you, sir?
Yes, sir.
Present with Mr. Kelly, your attorney, and the state's attorney.
Yes.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
We waive full reading, Judge Simpson.
In summary, this indictment alleges that on or about April 14th, 2022, in Jefferson County, Texas, you committed the first degree felony
This is yours. It's
of murder by shooting the complainant, the victim, with a deadly weapon, namely a firearm. Do you understand what you were charged with?
Sir.
If convicted of a first degree felony, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable?
Yes, sir.
An agreement has been reached in your case. If you would be pleading guilty, sentenced to 10 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
mine.
Yes, sir.
Moving slowly today. How do you plead to the allegation of murder in this indictment, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, Mr. Kelly. Is everything true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No
and
objection.
it's without objection, it's admitted. Among other things, sir, the states you are mentally competent to enter your guilty plea. This is being made freely and voluntarily. You know what you've been charged with. The indictment's read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1, it's made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, please, sir.
I will follow this agreement. Anything else to add on that? If
Not on that case, Judge.
Just, Your Honor, we're just requesting the allocution be allowed for tomorrow morning.
Yeah.
Bam.
But anything else to add on this?
No, Your Honor. no.
Okay, if nothing further, I will make the findings that Mr. Everfield, you are indeed mentally competent to enter your guilty plea. It's being made freely and voluntarily. You know what you've been charged with here. It black. It went black. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser inclusion of this. You are giving up your rights to a jury trial on the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer, all who so help you God. State's Exhibit 1 is made a part of the record for all purposes. Anything else to add?
Not on that case, Judge.
All right, I'm going. Do you understand what has happened today, sir? Okay. The only other additional finding the court is going to make is that the judgment shall reflect affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense, and that will be reflected in the judgment. Do you understand? Anything else? Now we have another case.
Yes, sir.
And this is cause number 23CR1270. And what do we,
Here's this one if you want to just hold it out and then.
we had to start over from the beginning on it. So weird. Machinery's not working right. It's a good sign. It's good luck in Haiti, but not here.
Haiti.
The second case on Mr. Everfield, and this is cause number 23 CR 1270. Does the defendant waive a formal reading of the indictment and the arraignment in this case?
Yes,
Can
I
we
do.
proceed in summary?
Thank you.
In this particular case, sir, the indictment alleges that on or about April 14th, 2022 in Jefferson County, Texas, you committed a third-degree felony of tampering or fabricating with physical evidence with intent to impair it in a murder investigation. Do you understand what you were charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in this case. You would be pleading guilty, sentenced to 10 years in prison. This one's concurrently.
Yes, Judge.
Will run concurrently with the murder case that you were just sentenced to in cause number 22-39802. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Yes.
So you're pleading guilty voluntarily, and because you are guilty,
Yes, sir.
I show you what's marked as State's Exhibit 1 as well in this case. Did you sign that? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, again, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation of your attorney on this case. All true at state, so help you God. State's Exhibit 1 was made a part of the record for all purpose. Pre-sentence report waived. If nothing further, I'm going to follow this agreement and find Mr. Everfield in this third-degree felony of tampering or fabricating with physical evidence. I am going to find you are mentally competent to do this. You will have an understanding of what you're charged with. You understand fully the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I so find you guilty of this third-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years, and this sentence shall run concurrently with the sentence in the murder case previously assessed today in cause number 22-39802. Do you understand what has happened, sir?
Yes, sir.
Anything else?
Nothing else.
That is all. Thank you.
Thank you.
10 years for murder? I used to think Texas was like, tough on people. I don't know. Let me know your thoughts in the chat. That seems lower than it definitely should be. But, we see some things that you think people should be put away for life and they get a slap on the wrist. So I don't know. I'm really trying to figure this stuff out. I really am. But I can't. Is it a plea deal? I believe it was, Ashley, a plea deal. That guy's got super lawyer if he got 10 years on that. Let's go back to Michigan Judge Elmore. I think he's doing a sentencing. Let's see how that goes.
Here in Western County, we're going to continue today's docket call by taking up the case of people of the state of Michigan versus Christian Corrigan. This is case number 25-14029 FH. Appearances begin with the prosecutor, please.
Nate Carnes on behalf of the people.
Good morning, Mayor. Please, Honorable Court, Kareem Johnson, B number 71988, appearing on behalf of Mr. Corrigan.
Thank you. Mr. Corrigan is here seated next to counsel, and Mr. Stephen Saladay is seated next to the prosecutor. He is the probation officer who has prepared today's pre-sentence investigation report. The one thing we need to note here is we had to adjust the sentencing date, so we'll know that that'll be changed on CFJ 145, page 1 at the top right-hand corner from September 8th to September 15th. That will require a change as to the credit, so we'll have to add 7 days there, giving us a total of 220 days of credit. That'll be changed on CFJ 145, page 2, and then of course noted at the top on page 1. I'll take just a quick moment to review my notes. All right, it doesn't look like I saw any corrections. How about you, Mr. Carnes? Any objections, corrections to make to the report?
Yes, Your Honor. OB 12 is scored at 5 points for one felony that was dismissed. That should be 1 point.
Oh, all right, no problem. I assume there's no objection to that, Mr. Johnson?
Correct, Your Honor.
Thank you. All right, so we'll go ahead and change that scoring for offense variable 12 from 5 down to 1 point. That will change the total OB from 15 down to 11. That still keeps it as an OB level 2 and does not impact the minimum guideline range. Anything else, sir?
Nothing further.
Mr. Johnson, how about you, sir?
Yes, Your Honor.
Any other amendments, corrections?
Yes, Your Honor. We'd asked the OB 19, which is currently scored at 10, be scored at 0.
Okay.
Reason stated, and we can see the court can look at conduct outside the sentencing offense.
Yeah.
If the court finds by preponderance of the evidence that the offense occurred. Here, the sentencing offense is possession of methamphetamine. What happened in this case was my client was walking down the street. He had contact with a law enforcement official who was asking to see if he was okay. He told him he was okay. The officer drove off. The officer recognized and ran his name, came back to arrest him for an outstanding warrant. When he got out of the car, my client said, "Wait a minute, what's wrong? I just met with you." And the officer believes that he took a step back and reached for something in his pocket, which was a cell phone that he was pulling out. My client didn't run. He didn't fight. He didn't do anything to evade or delay the arrest in this case. So for the possession of methamphetamine, which was in his book bag, I don't think he engaged in any conduct to try and interfere with the administration of justice of this offense. And we asked the people to dismiss the RNO. They were gracious enough to dismiss the RNO. I can't speak to what their motivations were in dismissing that, whether just to resolve the case or if they believe that there was a sufficiency of evidence issues. I know I've never tried a case in this jurisdiction, but I have tried these, what I call 5-second RNO matters in other jurisdictions, and typically juries tend to side with the defendant, especially with no punch, no kick, no biting, no spitting, any of that occurred. So I've asked the court, and I know the burden of proof here is lower than at a trial, but I still don't believe by the problems of the evidence that offense occurred. Yeah.
Thank you. Mr. Carnes, your response.
Your Honor, I'm in a difficult position here because I'm essentially substituting in on this file. As I read the description of the offense, reads like an RNO to me. I guess I wouldn't be opposed to taking this up at some point when watching the video, but I'm not sure we have time for that today.
Thank you. One moment as I take a quick. All right. You call them the 5-second RNOs. I call them the, the tensed up RNOs. Because, and I understand the dangers of being a police officer, encountering somebody, especially when you recognize the defendants. By the way, it's very easy to do in Westford County because we're pretty small. There's always a certain number of people that the officers see often. However, I've never been a fan, and I also think prosecutors need to get a little thicker skin with the officers and say, listen, when somebody just tenses and panics, if you touch me, I'm going to panic for a second. I do not think that those tensing RNOs are at all legitimate. Sorry, not at all. Sometimes are really not legitimate. The officers get very used to being justified in their actions based upon the danger that they do. So it's kind of a give and take. And I'm not trying to take it away from officers. Prosecutor here, I don't need to know why he dismissed the charge, although it's really easy to figure it out. You get a guilty plea because there's only 2.5 prosecutors and there's 4 or 5 public defenders, plus we got a team of conflict attorneys. So they have to cut deals. We all know that 95% of cases result in some kind of breach of agreement. So I don't put any stock in that portion. That was the throwaway charge. Plus, by throwing it away, you don't count it as a PRV 7 when it gets counted. It can be counted someplace else. I know when I was a prosecutor, I would always calculate all the scorings of the guidelines and try to figure out how can I give away a charge, but also keep a point on someplace else. So I don't care why they did it or what caused them to do it. The only thing I care about is what I see here in the report. Now, the defendant had 3 active warrants at the time. So the law enforcement, that part was left out, and that's okay. I don't think the defense attorney was hiding anything, but was left out. The officer turned around and after recognizing him and figuring out that he had some warrants. Once he had warrants and he went to go take the defendant into custody, the defendant didn't have a right to go grab it for his phone and quote, calling his people. They say, don't put your hands in your pocket. You don't put your hands in your pocket. Real simple. And you don't get to go, hey, well, I'm going to do something that you don't want me to do. Which is I'm going to call my people. I'm going to be in charge of the situation. And that's kind of the challenge here. Was it an attempt to interfere with justice? And that's really the question. Versus, and Mr. Corrigan, I'm not trying to be rude. Sounds like it. What I'm going to say is going to sound like it. Or was he just being a jerk? And by the way, people can be jerks. That doesn't mean it's an R&O. You can yell at a cop. Hold on, so no, don't say that. I'm not saying you were, but here's my example. If somebody goes up to an officer comes up to you and the officer says, all right, we're all done. And that person decides to yell, hey, you're a jerk, and calls them a handful of names, not a crime. I've got to try to make a decision here. Was it an attempt to interfere with justice, or was it just being a jerk? So that's how I look at these facts. Well, were you trying to get away from it? Yeah. Dude, you can't do this. Come on. Flailing arms a little bit. What the officer said. He took a step back while removing both hands from winter gloves. Well, that can make an officer feel concerned, right? You can't operate maybe a knife or a firearm with winter gloves on your hands generally. So I'm starting to look now and see, all right, trying to see it from the eyes of the officer. Took a step back. What I don't know is how many, it just says you took a step. I don't know what that means. I don't. You took a step and you made a fast reaching motion with your right hand arms toward your back right pocket. All right, now that starts to give the officer some concern. So it's elevating it just a little bit, or maybe, I don't want to, maybe the word elevate isn't right, but it's putting a couple pebbles of sand on that scale. So, and of course, the officer mentions here potential concealed contraband or a weapon maybe. One moment. So when you were trying to get to your phone initially, I don't know if I don't think that portion was an R&O. So now I start to look here at your actions and the officer's actions. I think were both reasonably understandable up until this point, maybe. It says Corrigan repeatedly stated he was trying to get to his phone all out. The officer was giving you verbal orders, don't reach for anything. So if at the time the officer was telling you, don't reach for anything, and you continue to reach for a phone or reach for something in your back pocket, even though you claimed it was a phone, the officer didn't have to believe that it was a phone. So in response, the officer continued to, quote, apply pressure and keep him pinned on the patrol vehicle, end quote. Then the officer or trooper orders you to turn around, according to the statements here, and place your hands behind your back. Then the officer said he attempted to turn you away from him and back towards the vehicle. But at that time, allegedly here, it says Corrigan pushed back against him, not allowing the trooper to turn. Then the trooper advised that if he did not, meaning Mr. Corrigan, turn around, he would take him to the ground. Corrigan still did not turn around, and Corrigan was placed on the ground. So to me, it appears that there is a preponderance of the evidence to conclude that from one perspective, maybe Mr. Corrigan was, they said they found the phone. Maybe he was reaching for a phone. But the thing here is in the presence of that moment, what is going on in the eyes of the officer? It's a little bit more than somebody goes to put cuffs on you. If you're a guy and you don't tense, I'd be surprised. Right? Most men, by the way, like to walk around with their shoulders up and looking tough. So anyways. But in the eyes of the officer who's trying to do his job, and he's given some instruction. I'm not a fan of this theory we have out there in the world today that, well, fight or resist an officer. Yes, you can resist an officer if their actions are unlawful. His actions were unlawful. There was a warrant. 3 of them actually. So the officer was not unlawful by stopping, was not acting unlawful by taking him into custody. And even though Mr. Corrigan may in the back of his mind thought, hey, I get to do this, or I get to call, quote, my people, the answer would be, no, you don't have the right to call your people. You have the responsibility to do what the officer tells you. So I'm going to say it's quite, it's a little bit thin. Let me take a quick look here at the statute. I'm sorry, the court rule, not the court rule, the statute for variable. 1 second. We're talking OB 19. OB 19 allows a scoring of 10 points when the offender otherwise interfered with Don't know if he actually interfered with, but did he attempt to interfere with the administration of justice directly or indirectly? Oh, sorry, that's the next part. Sorry, I skipped that. Did he attempt to interfere with the administration of justice? The court hereby makes a finding pursuant to the facts I discussed that the defendant by preponderance of the evidence was, albeit at a very limited scale. I don't think it's high, but it just says to interfere. And the court finds that there was an attempt to interfere, therefore the court will deny the challenge to OB 19. All right, Mr. Johnson, anything further?
No, Your Honor.
Or any other corrections, objections to any other point? I want to make sure you didn't think I was just talking about OBs.
No, Your Honor.
Okay. All right, allocution then, sir.
On the date of the offense, my client is walking in the county. He's not committing any crime. He's not intoxicated or drunk in public. As the court has indicated from reading the officer's description of offense, the initial contact between law enforcement and my client was just law enforcement trying to make sure that he was okay. The interaction was cordial. Both parties went their separate ways. The officer recognized him to be speaking to, ran him in lead, saw he had a warrant, and came back to effectuate the arrest. Again, my client wasn't high. Other than having a warrant, wasn't committing any crime. The court has made its ruling on what has happened next, but I want to just state for the court that after the client was taken into custody, as indicated in the motion that was withdrawn with the plea, the officer let him make the phone call that he wanted to make to begin with. And another individual came and picked up his belongings that weren't going to the county jail, and he was taken without incident. My client has been in the county jail now for 210 days. He has completed 5 hours of voluntary substance use treatment while in the Western County Jail. I have reached out and contacted Salvation Army Rehabilitation Life and Work Skill Program in Detroit. It was a program that my client was interested in. I have spoken to them about the intake process. If my client was sentenced to probation, they would be willing to admit him into the program. There's a 1-800 number that he would have to call. It is an inpatient program, and he would have to stay inpatient and be in inpatient treatment for the duration of the program. And if the court saw fit, and I believe the court would have to deviate from the guidelines now based upon the scoring. The court saw fit to hold any further incarceration in abeyance based on completion of the program. As a condition of probation, I think my client can and would comply with the program. In terms of, I do have a petition here for the program. In terms of supporting documentation, with this particular program, there is no application or anything for me to bring to the court. There's a 1-800 number that my client will call. He would either be admitted into the program or not, and they would arrange pickup for him, Your Honor. And I'd ask the court to allow us to petition for the court to participate in that program. I do believe that the outstanding issue here is really two. Not taking care of the simple warrants that he had and being in possession of narcotics. So he does have a narcotics problem. But again, he was not out on this particular day committing any underlying offense. He wasn't stealing or robbing or drug habit. He wasn't high out in the community posing a danger or a nuisance to other individuals that were out in the community.
Thank you very much, Mr. Jonathan. Mr. Carnes.
Thank you, Your Honor. I really don't disagree with Mr. Johnson's description of this event. It does appear the defendant was walking, not causing any problems, but he had 3 misdemeanor warrants for his arrest. And then while reviewing this file for sentencing, I noticed this seems to be a recurring issue: absconding on bond, on probation, on parole, and committing new crimes while on bond, probation, or parole. For those reasons, at this time, I don't think Mr. Corrigan is a good candidate for this kind of release to treatment, which obviously I've been in favor of in certain files. If he completes this sentence, including the supervision, spectacularly, hopefully that he's done. Hopefully he gets treatment while on parole. But I do think the recommendation here is reasonable in light of defendant's history, especially when I focus on his conduct on probation and parole. Thank you.
Thank you. Mr. Porter, I'm sorry, and by the way, in case you were going to say it, I don't know if you're going to, Mr. Johnson, I'll note that he wasn't on probation or parole at this time, when this picked up.
Okay.
Yep, but were you going to say something else? Looked like you wanted to, I thought you made a gesture.
Well, I didn't know what this court, this is my first sentence. I don't know if the court gives me a rebuttal.
If I generally don't, but if you, that's why I interrupted. I saw you do that. And the one thing I thought that you might comment on was that regarding on this particular case, you were Mr. Corrigan on probation, bond, or parole. So I don't want you to think that that's going to filter it. All right. Do you have anything further, Mr. Johnson?
No, we'd ask court, I understand the government's concerns. We'd ask the court to consider doing it in the inverse, sentencing him to a county jail sentence.
Yeah.
And after a determined amount of time, then allow him to petition to the Salvation Army Center.
Thank you. All right, Mr. Corrigan, it's your time to say something if you choose to do so, or something you wish to say, sir. All right, go ahead.
Okay, so
it's all right. You may remain seated. You can stand, whatever makes you the most comfortable. I know that it's not always comfortable to stand and
yeah. So I am actually already accepted to this program. I am also accepted to the Hope Grace Center of Hope in Pontiac. They're just waiting on this court date. And I understand that what I had was illegal, and you know, I do agree with the fact that I wasn't really out doing anything in particular to draw attention to myself and stuff. But I did go on a furlough. I came back clean, no issues. I was actually back to the jail early. I would just say that prior to this offense, 4 days prior to this offense, I sent a text message to my dad and asked him if I could move back into his house and get clean because I wanted to focus on my life. And he lived in Manton and I was stuck in Cadillac and I couldn't find a ride home for 4 days. And then I caught this offense. And then while I was in here, my dad passed away on April 5th. So I didn't even, you know what I mean? I missed that opportunity. And being incarcerated, I actually watched someone pass away in the jail. So I've already been through quite a lot in my jail stay. And I've been working on getting my medications right and trying to control my anger and my bipolar and stuff like that. So I would just ask that you do consider the treatment because I've already been to prison. I've already been on parole. I've been off parole for over a year now before I caught this offense. And it just seems like incarceration isn't the right way to do things. And I feel like I need like more than even a clinical rehab can offer me. I feel like the Salvation Army or the Grace Center of Hope would be a really good thing for me because they have 40-hour-a-week work program where you have to, that's how you get to stay there. You work 40 hours a week. And the Salvation Army program is 6 months at 40 hours a week. That's close to the longest time I've ever held a job in my life. You know, and I've been a trustee for 5.5 months in the county jail. I'm sure you've been seeing me around every time.
I know, I recognize what you're wearing.
I know, I wanted to stop. I wanted to be done. I was already tired of it, wasting my days sitting there hiding away from my warrants. I was tired of it and I wanted to stop. And I missed my opportunity. I missed to be there for my dad. I missed a lot of stuff and it's been life-changing. So I just ask that you consider all that.
Oh, I gotta start talking, so, all right. All right, so let me walk through this. I'm gonna hit several factors. And I'll tell you that I'm still sitting on a fence, so just wait till I get done. As I talk, maybe I'll convince myself one left side or the right side. Well, hold on, I don't like saying left and right because everybody thinks it means Democrat and Republican. I'm gonna fall to one side of the north, the east of the west. There we go. I'm not really sure. Mr. Corrigan, you present to me a confused position. You've been in jail now for 220 days in this file. You're 30 years of age, and you have been in constant trouble since the age of 15. Started a couple years before that. You had a couple year gap, and then starting in 2010, the wheels went off. Regardless of what I sentence you to here in a few moments, on CFJ 145, page 1, is a list of substances with which you have struggled. Beginning in 2007, when you were 13, 12 or 13, and then by the time you were 18, not even that, 15, you start adding a whole bunch of substances, prescription meds, marijuana, opiates, meth. Right now, unfortunately, on this page that I'm holding up for you, it just has one date, a general start date. We don't know exactly the precise date, but there are no end dates. Very first thing, no matter what I do for a sentence, you in your mind have to put end dates there for each one of those. That includes marijuana and alcohol, even though they may be legal. Till you fix you, gotta put some end dates there, or you're just gonna keep coming back to see me. I don't mind you coming back to see me if it's not in an orange or red jumpsuit. You can come back and say hi, but stop coming in jumpsuits. All right. So I'm really concerned, but the positive message here for me is, in your own mind, Christian, put some end dates there. And make sure those end dates are today or before today. All right, next. I appreciate, now I understand why Mr. Johnson, then you even commented on the fact that you weren't out causing trouble. You were out for a walk. But that negates the fact that had you been doing something else, you might have gotten in even deeper trouble. And there was nothing, the officers did nothing wrong as far as recognizing you, because of course that's why you were hiding out. That was the phrase you used, hiding from your warrant. Recognized you, pulled, took you under custody, and then found them out. It doesn't matter. You had warrants and you had meth. I do appreciate you weren't doing more stupid stuff, but you still had meth. Now, you have been to an inpatient program on an addiction treatment services. I think that's up in Traverse City. Was that at Tokoski Hall? Yeah. I think that was a couple of years ago. I don't remember how long ago it was. It was like 2021 maybe. Anyways. 20, yeah, all right, there we go. All right, well. As I continue, I look at your criminal history. This is probably the one thing you don't want me to talk about, but I have to. Your juvenile history had quite a few entries. Like I said, it began in 2006. That was a B&E. Looks like you were discharged from probation in 2007, and you made it about 3 years until getting picked up again. Now there you were placed into the Muskegon River Youth Home. You went AWOL relatively soon after. You had some other probation violations. I think you actually went AWOL twice, and I'm counting at least 1, 2, 3, 4 probation violations. In fact, while you were on probation there, you picked up entry 3 of 4 as a juvenile, and in that file, it also shows those same violations again. So we know that in 2010, it wasn't a good year for you. I know this one case here was dismissed, number 4 of 4. You picked up your first adult conviction while you were on juvenile probation. And in that file, you had a couple multiple probation violations. You had been on probation for all of 3 months before you picked up number 2 of 21 in 2012. Discount obviously entry 3 of 21 in the criminal history because there was a dismissal. But still within 3 months, you picked up number 4 of 21 while on probation. And we start to see that alcohol here is an issue right now already at that young age. We've got issues with our assault resistant drugs, but also B&Es. Then between 2 and 4, I already counted 4. That's when you committed the MIP while on probation. You made it 4 months before getting picked up again in district court while on probation. That was a drug possession. You actually had going on at about that time a series of 3 different sets of cases involving alcohol, marijuana, and drugs. You're still violating probation. Pick up another one 3 months after number 7 of 21. You picked up number 8 of 21. This one was down in Kentucky. Looks like that case was resolved in May of 2014. You made it 4 months before getting back up here to Michigan and committing another offense. Relatively minor in possession, but clearly as substances are an issue. Then you made it about a year between that and 2016 when you picked up 10 of 21. However, you had bond violations. Then you had another year gap. You picked up a crime without a license. Not a big charge, but you couldn't make it much more than a year. Then, while you were dealing with 11 of 21, you picked up 12 of 21 in 2018 while on bond. Between that case being resolved and the next case, number 13 of 21, you made it 4 months. Then between that and the next one, you made it 2 days. Yeah, you had been on bond on October 19th of 2018 and 19th, and you got out and you made it 2 days before picking up another series of charges. At the same time, you had another case down in Osceola County, one of your popular offenses, which is B&Es or larcenies. Then you picked up another one while on bond, same time as when possession is met. Probation violations. 4 months later, while pending the last warrant, you picked up number 17 of 21. You had probation, you had a probation violation there. And of course, we see now narcotics. Then you made it 6 months onto your probation. You picked up the next case. This was a destruction of property, sounds like out of the jail. There you had a probation violation. Then 19 of 21 occurs while on probation. That's more drug charges. And you had 11 parole violations while you were on supervision. 20 of 21 occurred while on parole, a relatively minor offense, operating while your license was suspended, denied, or revoked. To me, though, I consider those somebody doing what they want when they think as long as they don't get caught, they'll be okay. And then a year after being off of parole, you pick up this case. So your ability for supervision is quite questionable. You've had issues filing bond, filing probation, filing parole. You've had cases that overlap. You've had short times in between offenses. And basically since the age of 15, you've been constantly in trouble dodging law enforcement, but not doing that good of a job at it. You are, again, 30 years of age and you have 5 children, 5 different mothers. That's quite concerning because that means you're probably not out there earning money and paying child support. When I look at those drug uses, It's 1 to 2 times a week. That's quite a mixture. You got opiates, barbiturates, alcohol, cocaine, or alcohol, cannabis, and amphetamines. Don't know what it takes. Sorry that you lost your dad. I have absolutely no doubt that your childhood and the relationships you had with your family have contributed to the position in which you find yourself today. I also generally have found you to be fairly likable, but I'm afraid that that can also play against the court here. Good people struggle with substance use disorder. Even young people who've started off with it in the world with problems and family and home life and controlled substances and alcohol and marijuana, sets a pattern that impacts their brain development and it continues into them being an adult. So I'm not quite sure about what to do. All right, the sentences before the court will be as follows. The court assesses a $68 state minimum fee, a $130 crime victim right fund fee. Not going to do any court costs, not going to do any fine. I'm going to do a $300 attorney fee. All right, the court sentences the defendant to a prison term of 20 to 120 months with 220 days of credit. That is less than what was recommended, and I will also note that I find it to be proportionate and reasonable under both circumstances for OV-19. For instance, if I were to have granted the modification of OV-19, that would have reduced this in a Class D chart from OV level 2 to OV level 1. Today is an OV level 2. The guideline range is 19 to 38 months for the minimum. However, if I had granted the motion or the challenge to OV-19, it would have been reduced down to a 10 to 23 minimum range, which means my sentence is within both. Therefore, I think that it's even more proportional because I think it fits both theories of the consideration of offense variable 19. All right, Mr. Corrigan, Mr. Johnson's going to bring you 2 copies of one document. You're going to place your initials on one. Doing so neither elects nor waives any rights. It merely acknowledges receipt of this copy of the document. Your other copy. Yeah, yep, come on. Yeah, of course. Thank you. Place your initials again does not elect nor waive any rights. It merely acknowledges receipt of your copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal if there's been a conviction at a trial. However, based upon this plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Excuse me, the court is not going to make the payment of fines and costs contingent for parole. All right, I set them low, but I'm not going to let it hinder you on parole. Now, Christian, here's the reasoning behind it. You don't have to like it, but I'm just going to explain it. Stop it. It's just the best word I can come up with. 30 years of age, 5 kids. Take that loss that you had with your father and realize how important he could have been or was to you and how much more important he could have been had he continued to live. Now imagine how important you can be to these 5 kids. The part that my tendency here is to recognize that I see in you, and I don't think I'm wrong. If I am, then shame on me. I see a good person who just, for some reason, has something in his head that's not working right. I'm not gonna let that empathy that I have or sympathy I have for you allow me to let it perpetuate. I want you to think of 5 kids every day and your role in their life. And if you feel that loss from your dad, which I know you do, don't do anything further that's going to cause them to lose their dad. You can come out, get into rehab, you can become a peer recovery coach, all those things. I'm hoping you use this time wisely. Did I miss anything, Mr. Saladay? Or any further, Mr. Carnes?
No, Your Honor.
And anything further from you, Mr. Johnson?
No, Your Honor.
And Mr. Johnson, I did make some comments about some of the things about how he didn't, that may have sounded like it was arguing against you. I really thought you did a very nice job today arguing. I really appreciate that. I know you're not from the area. I know you're coming up here to help us out. And I know that you're helping a young man who's one of ours. And so I wasn't trying to argue against you, but I was just kind of responding to them. And again, thank you very much for representing Mr. Corrigan.
Yes, sir.
Thank you. You can, Mr. Johnson, you can just turn that into the clerk. Good luck. We're adjourned.
Okie dokie, folks. Before we go on to the next court, I want to make you aware of something. You can see on the screen right now the thumbnail for it. A video will be posting at 2 p.m. Eastern, 11 a.m. Pacific for everybody. Channel members have access to it now. And the thumbnail says it all. 93-year-olds dark behavior. It is one of the most bizarre and heartbreaking and shake my head kind of cases I've ever seen. And again, that goes live in about 90 minutes for everybody. If you're a channel member, it's live for you now. Be sure to check that out today. It's, again, one of the most bizarre, stupid, ridiculous, whatever you want to say, things I've ever seen. Let's go back to Judge Stevens.
Andrew Diaz, that's you. Yes, sir. Present. With Mr. Adams, your attorney and the state's attorney. And does the defendant waive a formal reading of the indictment and arraignment? In this case, can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about April 19th of this year, 2025, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon. You understand what you are charged with here?
Yes, sir.
This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreement's been reached where you'll be pleading guilty and placed on deferred or unadjudicated probation for up to 10 years. And is there any restitution here? No. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan in this case?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Guilty.
So you're pleading guilty voluntarily, and because you are guilty.
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand what you're charged with? The indictment's been read to you. Are you ready? Do you understand it fully? You are guilty of the crime charged in any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer here. All true.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes in this case. Pre-sentence report is waived.
Yes, sir.
I will follow this agreement and find, Mr. Diaz, you are pleading guilty today voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, Your Honor.
There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. in this case. However, court is going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. You do well, it can be shortened to 1/3 of it. There will be terms and conditions of probation, including anger management, which helps you make decisions under crucial decision-making situations. And that will help you. Also, the court, even though you have not been found guilty, so long as you follow these terms and conditions of probation, court finds there is sufficient evidence to support an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. It will not have any practical application unless you fail. Then your probation can be revoked. You can be then found guilty, sentenced up to 20 years in prison, and that prison sentence would have to be served at least 50% because of the affirmative finding of a deadly weapon. So a lot riding on you doing well. So are you going to do well?
Yes, sir.
Okay, it's up to you. Anything else? That is all. Please just talk to the probation officer and
Judge, there's an issue we need to deal with the trial docket on Jim Bailey. There's some subpoenas that were, some motion to quash were filed that I think we need to deal with an issue that's come up many times if we could, please, sir. We've got Mr. Stelly here's filed the, I think the objections to him.
Where that's going to.
There's also, wasn't there another one?
Yeah.
Howard Price?
Howard Price, yeah. Yeah, we'll deal with them both.
Okay.
Did you get my response? I emailed it.
Would we?
You won't, I have
That's a question. I don't know.
I emailed everybody. Mr. Stelly was a part of the email.
That was attached to files.
You want to take a time, look at my response before we, so I have some other matters.
This is just an issue that's come up. I think we need to deal with it so we can figure out what to do from here on out.
Okay, it's not set in the queue for trial today, correct?
No. Well, no.
It's on the trial docket, but it's.
No, I didn't name it on trial,
No,
though, right?
No,
I named others.
No, so that's why, but this is going to come up again and again, and we kind of need to have an answer.
Okay, we're going to stop everything we're doing and work on this then, right? That's what everybody wants.
Yes, sir. Well, look at it, sir.
Did you see my response? Yeah, I want to read my response before we back it down. Yeah, so we can do the other stuff.
This is Bailey, right?
Because he had a chance to read my response.
Yeah, I hadn't read it.
Right.
All right, I think it's going to take them some time to sort out what they're doing. So while they figured that out, let's go back up to Michigan and return to some barnyard justice.
Crawford, the record should reflect Mr. Crawford's now present by video from Mexico County Jail. This is the final status conference and plea cutoff. In this case, we have trial set to begin on September 29th. Mr. Fragel, have you had an opportunity to go through any current plea offers with your client?
I have, Your Honor.
And how does he want to proceed?
We'd like to plead guilty to counts 2 and 3, CSC second degree, person under 13 years old. And count 1 would be dismissed.
Mr. Rolla, is that a correct statement of the plea offer?
That's correct, Judge.
Mr. Crawford, have you had an adequate opportunity to talk to your attorney about this plea agreement?
Yes, I have, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Crawford, are you currently on any kind of probation or parole?
I am not, Your Honor.
All right. And you understand that the maximum possible penalty that you can face for each of these charges, which is criminal sexual conduct in the second degree, each of them carry a maximum possible penalty of up to 15 years in prison. Do you understand that?
Yes, Your Honor.
And that by law, conviction for those offenses requires lifetime electronic monitoring once you are released from any kind of incarceration. Do you understand that?
Yes, Your Honor.
With all of those things in mind, what is your plea to each of those charges here today?
Your Honor, I plead guilty to both of those.
All right, I'm going to go through your rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all of those rights?
Yes, Your Honor.
And you understand that by pleading guilty, you're going to be giving up and waiving all of those rights, and you won't have them anymore, and that includes the right to have a trial.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal by leave. That means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've talked about here on the record today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty of each of these crimes?
Yes, Your Honor.
All right, Mr. Fragel, the information doesn't really contain much factual information for me to go on. Can you question your client to establish facts?
Certainly, Your Honor. I believe we'd like to amend the information to the on or about date. It should be April of 2016, as opposed to January 1st of 2018.
Mr. Rowland?
We have no objection to that, rather, for the purpose of correct.
Okay. So we'll note that for the record, and Mr. Rowland, will your office prepare an amended?
I've already made a note of that effect. Thank you, Judge.
Sorry. Thank you. Mr. Fragel.
Mr. Crawford, were you in Otsego County during the month of April 2016?
Yes, I was, Your Honor.
And during that time, you were alone at a residence in Otsego County with a person under 13 years old, correct?
Yes, Your Honor.
That person was a female?
Yes, Your Honor.
And while you were alone with her, did you make sexual contact with her?
Yes, I did, Your Honor.
You can call me Mr. Fragel. However, the sexual contact as to count 2, describe that to the court, what sexual contact you made for count 2.
I pulled out my penis and I showed her it and she touched it. And I also touched her buttock and the inner thigh by her genital area.
Okay, so for count 2, she touched your bare penis, is that correct?
Yes, sir.
Was that done for a sexual purpose?
Yes, it was.
And for count 3, you touched her inner thigh and her buttocks, is that correct?
Yes.
And that was done for a sexual purpose?
Yes, sir.
And both of those incidents, Mr. Crawford, they occurred here within Otsego County?
Yes, Your Honor.
Okay. All right, Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Fragel, are you satisfied with the factual basis?
Yes, Your Honor.
Okay. Mr. Rolla, are the people aware of any threats, promises, or inducements of what's been placed on the record?
None by the people, thank you.
Mr. Fragel?
No, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking?
Yes, Judge.
Mr. Fragel?
Yes, Your Honor.
Thank you. Mr. Crawford, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of the charges in this case. court will accept the guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, somebody from the probation department will be in touch with you to complete a pre-sentence report. And you'll have an opportunity to go through that with Mr. Fragel prior to the sentencing hearing. Anything else?
Just that the court's taking the child matter off the docket.
The court, yeah, in light of the plea, the court will adjourn the jury trial currently scheduled for September 29th. Mr. Fragel, anything else we need to address?
No, thank you.
All right, thank you, Mr. Crawford. That's all for today. The court's going to disconnect at this time.
Your Honor.
So a little behind the scenes inside baseball so you kind of understand how I do things here. For the most part, when I key up a hearing, I don't know what's coming. We're generally a few minutes past being live. Sometimes we're flat live, but usually I queue stuff up so that it's ready to go from the start. But I don't screen stuff ahead of time almost always. And I say that because it's amazing just how many of these situations we stumble into through the course of a week here at TCF. And what it says about us is, as a nation, is incredibly frightening and sad. Just my thoughts on it. I hope he gets some severe barnyard justice, to be honest with you, though. Let's see what this one's all about.
The status is fine.
Sure, Judge. This is our first appearance in circuit court on this matter. While we've had some initial discussions with the prosecutor's office, we have not yet come to a resolution. I'm hoping that we can do that. There is another matter pending in Antrim County with the same allegations. So we're hoping to resolve all of the cases at one time if possible.
What, in terms of the time frame for the next hearing?
I think if the court gave us 45 days, we should be able to come to a resolution.
Mr. Rolla, do you have any objection to that?
I would agree with what Mr. Williams indicated on the record. We have no objection to the 45-day jury.
Okay, so we'll set this for a plea hearing and status conference. I will set it for the court's full motion day in November. So that'll give us about 45 days. So Ms. Willie, it's just important between now and then that you stay in touch with Mr. Blumberg so that you're ready with a decision about how you want to proceed at that time, okay?
Second.
Mr. Roll, is there anything else that we need to address today?
Not in this matter, thank you.
Mr. Blumberg?
No, Judge, thanks very much.
Thank you.
Thank you, sir.
Okay, let's go back to Judge West. We got to her towards the beginning of the show and haven't had a chance to go back.
All right, have you been getting that patch switched out like you're supposed to?
I didn't have them, and I just started a job, so I didn't have the first ticket or nothing, but I just started a job. I get my Friday.
Okay.
I had got the first one.
Have a seat in the jury box. Let's get you tested this morning. And then you've got Kevin Diaz, Mr. Rojas. Kevin Diaz. I don't see. Oh, okay. She's gonna need you over there as well. You did? Okay.
I just sent the judge.
All right, thank you, Mr. Coleman. Anna DC Sanchez Diaz. It's okay.
concerning transportation.
Okay, well, so this is gonna be to a lesser, okay, I'll make that notation on the indictment as well. And it's transportation code, what's the code do you know the section by chance?
Charlie and I talked about it.
Do y'all have it written down?
I don't have it.
Fleeing? Fleeing?
545.421C.
545.421C. I got it. Okay. All right. Are you Kevin Sanchez Diaz? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Sanchez Diaz, the state has elected to proceed on the lesser included offense. And what level is that?
It's a B, I believe.
Is it a B?
It's a B, Judge. It's my understanding.
Okay. The state's elected to proceed on the lesser included offense of a Class B misdemeanor of fleeing a police officer under Transportation Code 545.421C, and that's from March 5th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a, and I said fleeing, but it's eluding actually.
In the GPS code, it says
Fleeing.
both, Judge. It says
Both.
fleeing or eluding.
Okay, okay. So it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tender's number 1.
No objection.
It's admitted. Is there any evidence that Mr. Diaz is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 1 year. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, if you successfully complete it, the case will be dismissed. You'll never have this conviction. The other side of that is if you violate any condition of probation, you can be brought back into court. You could be found guilty and you could go to the Jefferson County Jail for up to 6 months. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. You need to have a seat here in the courtroom. The lady that's sitting at that desk right there is with probation. She's going to call you up when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you.
Barbara, thank you for gifting the membership. I appreciate it. I'm betting you were trying to target Liberty Bell with that one. Swing and a miss, but thank you, and congrats to our new channel member. Let's go back to McNally. Let's go to Dad.
Sharp, unmute yourself and put your video on.
Mr. Sharp, you need to start your video, sir. Your name?
Faraz Sharp.
Let me call this again. I don't know if I called the whole case. Faraz Cortez Sharp, 24G700688. I'm sorry, your name again?
Faraz Sharp.
Good morning. I will be team 1520. I'm Deaf Mr. Sharp, who is present via video.
All right, so he was ordered on August 6th of 24 to attend the domestic violence program with a week-long follow-up. I'm sorry, with 12-week follow-up, rather. How's he going to proceed?
Yes, sir. We are going to be pleading guilty with excellent names and I'd ask for the applicable to LMD prior to being imposed.
Is that what you want to do, sir?
Yeah, yes, sir.
If you plead guilty, I want you to understand this would be a first technical violation, I suppose. But he absconded, right?
I think he was in jail.
For how long?
February 13th until May 2nd.
Well, I want you to understand, I'm gonna go ahead and address all that. But if you plead guilty and you absconded for 60 days or more, you could have a 93-day jail term handed down. And actually, on April 3 of 25, I resentenced him. I had revoked his status, 7694A. So I'll take the plea. We'll go from there. If you plead guilty here, sir, you're giving up your right to a hearing. Do you understand that?
Yes, sir.
You have the right to question their witnesses, to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
To the charge that you failed to complete the domestic violence program with 12-week follow-up, how do you plead?
Guilty.
Did you fail to attend and complete that program with 12-week follow-up?
Yes, yes, sir.
Anybody forced you to plead guilty?
No.
Counsel, what is he doing?
He is in the class. He had completed.
Call in Emily, please, Vince.
Completed 3 of the classes prior to him being incarcerated, and he has completed 3 since.
Do you have proof of incarceration?
I personally do not know.
Do you have proof of incarceration, Mr. Sharp?
Not on me, but when Emily comes in, she knows. She can tell you.
How long were you in custody?
February 13th to May 2nd.
To what?
To May 2nd.
All right. Did I sentence you when you were in jail?
No, you didn't.
I sentenced you April 3. If you were in custody until May 2nd from February 13th or 16th, I don't know how I could have sentenced you. I don't know how you could have been in custody if you weren't in custody. How could you have been in custody if you were here on April the 3rd of 25?
I wasn't. I was in the courtroom from Zoom.
Listen to what I'm telling you. You and your lawyer just told me that you were in custody from February 13th to 16th until May 2nd, correct?
Yes.
I sentenced you on this case the second time after I revoked your 7694A status on April 3. You said you were not in custody then. If you were not in custody April 3 and were in the courthouse, I don't know how you could have been in custody between the second week of February and in May the 2nd.
No, I was in custody. I was just on a Zoom in custody talking to you.
They might have zoomed him from the jail.
That's what I'm asking you. Are you telling me you were zooming from jail?
Yes, I was.
Mr. Sino, your name?
Yeah.
Was he in custody from the second week of February until May the 2nd?
Yeah, I don't know if those are the exact dates, but he was in custody on that pending case.
What pending case?
He had a pending DV out of 23rd that got bound over to 3rd Circuit.
And was that
So that was, we had discussed because you entered the conviction.
domestic 3?
It was just a regular DV.
Well, it can't be if he was sent to.
It was, so, okay, I can tell you. So it was count 1 was assault with, intent to do great bodily harm. Yep, and then count 2 was the DV. It was a section.
That involved this DV what?
DV second.
Did that involve the same victim as there was in my case?
Yes, and this was the case I came to talk to you about because technically the offense date, because the conviction was entered and you resentenced him in April. The offense was prior to technically this case.
Okay, what was the offense date on that?
I think it was October.
I sentenced him August the 6th of 24 initially.
And the offense date was October 17th of 24.
But he was on probation here. October 17th of 24. Is that what you said?
Yeah.
Well, I didn't revoke his status until March 20 of 25. That's still a violation of the no contact provision. Maybe I misunderstood. I remember us talking about that.
So that's why I didn't include it. I can, but we went kind of back and forth because
What happened with that case?
so he is on probation. He has since moved to Paw Paw, Michigan, so his probation is out there, but he is here. It is for 3 years. He was sentenced July 16th of 25. And it looks like he's got to complete a DB program. He's got to complete cognitive behavioral therapy. No contact, no threatening behavior, no weapons. And money.
Does it say how many, do you have the order of probation?
From the other?
Yes.
Yes, I do.
How many credits, how many days credit does he have coming?
83.
He's not doing too well. Mr. Hickey?
Yes, Your Honor. So I am the substitute. I'm not really up to date with everything for Mr. Sharp, but from what I can tell, it seems like he's completed everything other than the domestic violence class. He is in that class currently. I know his probation is supposed to end in October, so I don't believe he would be able to finish the class by then. I'm asking that we extend the probation like a month and a half, which should give him enough time to finish it. He did, prior to incarceration, complete 2 or 3 classes. Since then, he has done 3 with 1 just last week. So if they give him credit, it'll only be 6 more weeks if they don't.
Let's do this. I don't mean to interrupt you. I'm gonna go ahead and set a sentence date. Well, wait a minute. You said probation.
I think it ends
It's October 3rd. Yeah,
I think he's giving credit for what he did before he was incarcerated. As of September 4th, he had 2 follow-ups completed, is what they're supposed to be.
They did 1 last week, so he has 3 now.
give me 1 second here. Where's Pawpaw again? Sir, where is Pawpaw again?
Miss, like near Kalamazoo, it's like 2.5 hours from Detroit.
I need to think about this. I'm not enthused by the fact that you didn't do the program that I ordered you to do, which is supposed to be to rehabilitate, not punish, and yet then you went out and picked up a 10-year felony. That's what he pled to? GBH?
Yeah, there's 3 counts, and then the DV second, and then the knowingly assaulting her, assault and battery of a pregnant.
I mean, that. Yeah. Yeah. I need to see the reports. I want to give them to Mr. Nahikian. I'm setting a sentence date in 2 weeks. Some may say, well, 83 or 87 days is enough. Maybe it is, maybe it isn't, but I don't like what I see here. I'm accepting your plea. We're setting a sentence date. You need to appear in person. And I'm going to set it on Mr. Nahikian's next day while probation is still, he's still on probation status until October 3. So do we have like September 29th, maybe?
Yes, September 29th is your probation day. Let's do 9:30.
Yeah, and that'll give you a little extra time to be here, okay? So I would like you to send whatever you want to send to probation, to Ms. Tessino, and I can look at that before that sentencing date, but defendant to appear in person, okay? Do you understand that, sir?
Yes, sir.
I'll see you September 29th at 9:30, okay? Thank you.
Okie dokie, friends, we've hit that time of the day where it's time to say goodbye. And I hate this time of day because I like spending time with you guys. But good news, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier if you're a channel member. If you're not a channel member, you should fix that. Just go to the main page of the channel, hit join. It's a whopping $2.99 a month. But you get early access to videos. You get to join us on the pre-show where starting today, we did it for the first time today, you have the ability to quote unquote call in and actually interact during the pre-show. So it's all sorts of fun and I highly recommend it. And tomorrow is the glorious return of Sidebar after a 1-week hiatus. So we'll be back for that tomorrow, 8 p.m. Eastern, 5 p.m. Pacific. So looking forward to that as well. Go have yourselves a good Monday. Last week was crappy. So let's make this week a better week for all of us, for the country, for everybody. And I look forward to seeing you tomorrow. Take care. God bless.